that basically this matter be heard upon deposition and argument. They have no ability, basically, to cross-examine him on this new additional material. No ability at all to question his methods or methodology in respect to that new material. Is that fair?
Your Honor, I understand the court's position on that, and I would say that the better remedy that would meet the interest of justice on this is to allow them to do just that after argument. To allow them, we can do that tomorrow. We can do that, this evening, and then we can submit the deposition supplementally to the court for its decision. That would be something that could meet the interest of justice to still allow them to cross-examine Mr. Kamsel on these issues without denying us any reasonable means of bringing this to the court's attention, since there's no other way that we could have gotten this and to submitted it to them any earlier. We literally submitted this at the earliest moment we could have in order of getting the data, comparing the data, producing a very short report explaining how the data was compared, and then providing it to the defendants. They should have the ability, but they certainly have the resources available in a document subpoena situation to use their own experts, their own resources to compare this data and say if they think that we got anything wrong, that it's fewer than 4,000 non-citizens who voted in this case. They haven't done that yet. They've had, at this point, a similar amount of time that we've had to do this, and they haven't done that. But if they want the opportunity to depose Mr. Kamsel on that, we'll make him available for a deposition, a very short deposition after this. We can submit it to the court supplemental without further argument.
Mr. Hamilton, any final comment on this issue?
Your Honor, took the words out of my mouth. The statute anticipates evidence to be presented by deposition and the argument of counsel. That hasn't happened here. This contest was filed on November 17th. That's quite a while ago, and counsel had plenty of time to secure whatever data he needed and to produce the declaration or expert testimony. Your Honor gave clear deadlines. If there was some issue, then counsel certainly could have filed an emergency motion for this court to leave or even approached us for how to deal with that. He did neither. The court has indulged counsel at every turn by providing ample opportunity for discovery, but this is both inconsistent with the statute and fundamentally unfair to the court and to the defendants. So we would ask that this
The order of the court, go ahead and strike the supplemental declaration of Jesse Kamsel. I believe for the reasons I clearly indicated, stated one that had a disclosure deadline of November 25th, 2020, which I might add, none of the other experts by the famous were even disclosed on that date. They were all disclosed later. I don't know about disclosure, but the reports were not done until November 30th, I believe, in respect to that. But I don't allow all that. Not striking anything other than this current declaration for two reasons, primarily. One, its way, two, primarily under NRS 293.415, clear to this court that I am basically limited depositions and argument in respect to making a determination in this case. Regards that, the reason for that, clearly in the court's mind, ability to cross-examine and verify the information and make sure basically it's fair to both sides. So, that in mind, I want to move forward in respect to that. It's my intent to give each side approximately an hour. We may take a break somewhere along the way in respect to this matter. In regards to that, you can reserve part of your time for rebuttal. Each side, you have an hour. Want to go 30 minutes and reserve your time, that's fine with the court. However you want to do it in respect to that, fine. I do have one other question that the court thinks is important to start with, and that is, what is the evidentiary standard that applies in respect to this? I think it's important that we go through the evidence and look at the evidence, that we understand what the standard is that we're going to apply. Is it a clear and convincing standard, or is it a reasonable doubt standard? So, given that, and all, if you want to comment on that, again, just short. I've read all the briefs, and that's short. not making a decision which way. I just kind of want to give a flavor for everybody and what the course we're going to look at.
And I understand that that would be an important point for the court to consider, is because the statute itself is silent on the standard of proof that would be required in a case like this. The defendants have cited law in other jurisdictions, but of course, since this is a creature statute in Nevada, it would be more appropriate to look at how Nevada handles situations like this. The default is always in a civil case preponderance of the evidence. That is the default burden in a civil case, and this is a civil case. It's an unusual case, and it's understandable why there wouldn't be a lot of case law defining some of this. But short of any intent of the legislature, and we're aware of no other intention of the legislature to increase the burden of proof to a clear and convincing standard, as the defendants urge the court to do, the right thing to do is go back to the civil standard that we are very familiar with, which is preponderance of the evidence. From a policy perspective, that's the right answer too. We are trying, as the court said when the court took the bench, to determine whether every vote was properly counted, every legal vote was counted in an election like this. There is no reason to give more deference to one side or the other in that determination. The proper thing to do is to weigh the evidence to see whether or not the decision to certify the electors for Vice President Biden was appropriate. And so consequently, since there's no reason to favor the defendants more or the contestants more, the preponderance of evidence standard is the appropriate use here.
What about NRS 293.410, which talks about reasonable doubt? It uses kind of a reasonable doubt throughout that. It talks about reasonable doubt. Is that similar to preponderance of evidence, or is that a little higher standard?
And that's an interesting use of reasonable doubt in that statute, because it's not the reasonable doubt, very clearly, that we would be used to in a criminal case. It could be read to say that it could be read to offer a standard much more favorable to the contestants, quite honestly, of saying that if there's a reasonable doubt in the outcome, that the contest should be granted. It's difficult to see exactly how that would work in the civil setting, Your Honor. And that's why I think it's more appropriate for me, and quite honestly, hopefully, it gives me a little bit more credibility to you to say I don't have to just throw up as somebody sitting on this side of the courtroom who has a burden, some burden, that I just have to have almost like a probable cause type standard. I think it does have to be more than that. It has to be that we do have a burden to meet here, a burden that we will meet, that we're very confident we will meet, I think the way a reasonable reading of the reasonable doubt language in 210 means that it's similar to the preponderance of the evidence standard that otherwise the court would use in this setting.
Mr. Hamilton?
Well, Your Honor, I agree with counsel to the extent that the Nevada Supreme Court has not yet defined clearly the burden of proof required in an election contest. But an election contest, by its nature, is asking a court to do an extraordinary thing, which is overturn the results of a certified election. And so for that reason, courts around the country typically embrace a clear and convincing evidence standard. California, Illinois, Kentucky, Maryland, Montana, Ohio, Oregon, a variety of states. We've cited them all in the brief. So it has, obviously, if the statute set a standard, that would be the standard that would apply, or if the Nevada court had spoken, that would be obviously controlling. Here we don't have that, so we have to look at, I submit that two things guide the standard. First would be how are election contests and that is they use a higher clear and convincing evidence standard. Second would be more of a functional approach. The cause of action sounds, at least in part, in fraud. And fraud under Nevada and the law of virtually every state requires a higher evidentiary standard. So for both reasons, I think that the clear and convincing evidence standard is the one that should be applied by the court here. Ultimately, and I know you don't want me to argue the rest of the merits of the case, ultimately I'm not sure that it's positive here because I think the claim fails under even a more relaxed preponderance of the evidence or reasonable doubt standard, Your Honor.
Well, I would reserve ruling on that issue. I think it's kind of a difficult issue in regards to this.
And it may or may not make much difference in getting down the road. The other question I have is there was a certification of the election results by the Nevada Supreme Court. Does that have any impact on this hearing? And again, if you look at the statute and the timetables that things have to be done under Nevada law, and you do have time periods in which to file a contest and it was filed properly within the time period. So I'm not sure it technically has any impact. So just a final comment.
Your Honor, I think that's a very good question, something that we looked at.
I always like to hear that. I ask the very good
It's a good question from the very nature of the fact that came from the bench, I know. Your Honor, the contest statute is I think, quite clear about the timing and the fact that the ministerial action of certification by the Secretary of State and then the governor does not take away the court's ability to enter an order on a contest. Of course, just by the timing that the General Assembly has laid out on that, I think is very clear. And up until, matter of fact, the law actually is that you can see from the legislative history on the contest statute that it is anticipated that the timing has to be so truncated because no one is able to take the oath of their position until the contest is decided. And so that is the important time frame to look at for the contest position, is to actually go down the legislative history. If we haven't cited that, we can get that and provide that to the court. That the important thing is whether they've taken their oaths to actually then begin their terms, and they can't take those oaths until the contest is actually decided. And so that would be separate and apart from the certification process by the Secretary of State. Otherwise, the timing laid out by the legislature just would be impossible for there being an election contest at all. It would render the entire statute a nullity.
Thank you. Mr. Hamilton?
Your Honor, I think Nevada law speaks to that in NRS 23417, sub 4. Whenever an election is annulled or set aside by the court, and the court does not declare some candidate elected, the certificate of election or the commission, if any has been issued, is void and the office is vacant. So I think, without having spent a lot of time thinking about it, that the action by the Nevada Supreme Court does not prevent this matter from going forward to a judgment.
Thank you. I agree with you.
I agree with both of you. Thank you in respect to this matter regarding that. So at this time, basically, the court is prepared to go ahead. Now, if you want to start with the argument, again, we're kind of limiting everybody your time. You can reserve whatever time you want. The law clerk is keeping track. She's very diligent at this, so. And I want you to know that I've read all the briefs. Up to the brief, up to that, and I've read as much of that as I possibly could from 5 o'clock until noon today in respect to that. And there's a significant amount of pages there, but I concentrated primarily on what both counsel know. I read primarily the depositions of the experts in regards to this particular matter. I did feel time going through that, and I felt that was probably one of the most important places to start. So with that, go ahead.
And, Your Honor, we understand that there's a substantial amount of submissions in this case. In a very truncated position to get it all forward for the court. I was reminded of the old adage that if I had more time, it would have been shorter. In this case, we think that almost everything that we have given to the court is something that is important for the resolution of this matter. It is all critical information that we've been able to gather in a month, and we appreciate the court's consideration of that and taking up all the time that the court has in looking at everything. We are actually also just put together something this morning that we thought might be helpful, and that is an additional exhibit index that gives the particular exhibit and which binder it's in for our binders. Can we hand that up to the court?
Yes, absolutely.
Okay.
I'd like to have that. Thank you very much.
Thank you. And we will make sure that we get one of those to opposing counsel promptly as well, if it hasn't already. Your Honor, I'm going to go for about 35 minutes right now, and then I'm going to withhold the rest of my time before rebuttal, if I can do math. Your Honor, this case is about the failure of the electoral system in one election. And no one ever wants to say that, but it's true. The evidence proves it. The questions are, how did this happen? Who's responsible? And what do we do about it? Our free, fair, and open elections are a source of national pride. We spend untold millions of dollars around the world preaching the benefits of election integrity. We make sure that elections are decided by the people who vote in them and not by outside actors trying to influence the results. Voters who are the ones that are legally able to cast those votes, and the importance that every voter gets only one vote. The evidence that we have submitted is compelling. It shows that election officials planned and implemented an election system that would be highly susceptible to fraud, that it would ignore the best practices developed over the years, and eschew meaningful observation. This was made worse, as Mr. Gessler's expert testimony makes clear, by the legislature's decision to adopt AB 4 and take us to a system of universal mail voting at very much the last minute, without a sufficient amount of time to clean the voter rolls and implement a plan to ensure voter integrity.
Let me ask you about that, and that's
Basically the vote counting machine, the counting machine that they did in respect to the ballots, is that correct?
Are you talking about the Agilis machine in Clark County, Your Honor? Yes, Your Honor.
And wasn't that issue determined by Judge Wilson in the Cross case and the other cases that have been filed throughout the state of Nevada? And I'm raising that because the defense raised an issue of preclusion, and we're going to get to that at some point in time. That's right. And that I basically on issue of preclusion, is that something I should even consider?
Your Honor, I think the clearest answer, the reason why the answer is no, is that Judge Wilson decided that there wasn't standing to bring that challenge. And anything decided without standing is a nullity and can't have preclusive effect. There were other reasons for his decision, but because since we would be looking, well, regardless if we'd be looking at issue preclusion or claim preclusion, the lack of standing would be dispositive on that particular issue. you also do have the fact that the parties are different between the two contests, and so for res judicata purposes, that would have an effect. And one of the reason that standing was so important and why you wouldn't have a res judicata or collateral estoppel issue come up here is because essentially the argument wasn't right yet. We didn't know at that point if it was going to be a problem. And so you can't really say on one hand, well, we don't know if this is a problem yet because it happened pre-election, and so the election actually comes, we see it is a problem. And then say, well, it's already decided when it was said it wasn't right. That kind of reasoning doesn't really work for a preclusion narrative. So the primary issue that we're going to see with the use of the Agilis machine here is one that's purely statutory. As far as the legal problem. And then what flows from that is going to be the evidentiary problems, which there's not going to be the preclusive issues on the evidentiary problems, because even if the Agilis machine had already been determined to be legal by Judge Wilson's previous ruling, the issues at play is whether the authenticated signatures, whether they were authenticated by a human or by a machine, whether they were properly authenticated, whether they led through fraudulent votes. And we do have evidence that we've submitted to the court that says that the answer that we've been able to determine without really any use of civil discovery, and certainly not what you would normally get in a fraud investigation of this sort, is that yes, the signature verification system, machine, human, whatever, let through bad votes. So the statutory issue is going to break down, and I don't want to, well, we're there, so I'm just going to address it if it is easier for the court. The statutory issue is that even in AB 4, which is of course just passed this past summer by the legislature, it decided, it required that signatures be verified by the clerk or the clerk's employee. Clark County is a little bit different because there's a county statute that specifically says that the role of the clerk is assigned to the registrar when it comes to election matters. And so that statute, for Clark County purposes, which is the only places that uses this Agilis machine, means that essentially the registrar of voters or his employee has to verify those signatures. And then it says, there is another statute that says, I think it's section 25, that says that, I might be wrong on that, that computers can be used except as otherwise provided for. So this is one of those specific versus general and exclusio unius, expressio unius. I'll try to remember my Latin on that, but when you name one thing of the similar category, things of a different category are necessarily excluded. So using our statutory construction canons, we see that the legislature for signature verification specifically wanted to exclude computers being able to do that work by requiring it be the registrar / clerk or an employee. This makes sense. It makes sense that knowing that there would have to be this signature authentication process with universal voting in AB 4, that they would want to have, which ended up not happening, a robust signature verification system and process. So that's why, if you look at the statute, it's very clear that this cannot be done by computer. It had to be done by people. So aside from any of the other factual issues with the machine, just the very nature of the statute means that it was improper to use it to authenticate signatures, especially for the fact that you had universal voting without without really cleaning the voter rolls sufficiently beforehand. The preclusion issue there, since the decision before wasn't right, there was no standing, the parties are different. There is no preclusion here, and that is still proper for the court to consider. Hope I've answered the court's question on that.
All right, thank you.
Thank you. Having that time to clear the voter rolls and implement that plan for election integrity and voter ballot integrity, it became a real problem in this election. And it was not an unforeseeable problem. It was a problem that people were making clear all along, that there was going to be issues if we didn't take robust efforts in order to make sure that every voter was only voting once. As a result, there was a system that was ripe for the picking when it came to fraud. And the fraud came. I need to address the elephant in the room. There's a narrative that everybody here has heard. It's a narrative that's been repeated in the media time and time again, traditional media, electronic media, social media. It's this beating of the drum saying that there's no voter fraud, there's no widespread voter fraud. It seems that if people think they say it often enough, it will make it so. They just say it simply doesn't exist. And they chalk eyewitness testimony up to one-offs. Sometimes they just ignore evidence completely. They also ignore the fact that fraud cases usually are prosecuted when it comes to something like voter fraud. Oftentimes, it might be a federal prosecution, state prosecution. Gets investigated by law enforcement for months, years. The prosecutors go in with grand jury subpoenas, the FBI subpoenas for documents. And they are able to have the full availability of almost whatever evidence they want, as long as it's not subject to some privilege. And over a long amount of time of doing that, they can actually bring a case for voter fraud or for any other type of mail fraud, wire fraud, fraud for getting people into colleges, whatever it might be. In this case, what the contestants have done is 1 month ago was the election day. In that short amount of time, using few resources, some very dedicated people, they have put together a robust body of evidence showing the voter fraud that came in this case. They did it without the discovery tools that are normally used in civil cases, without law enforcement support, and unfortunately with a great amount of obstruction and stonewalling from people who should have known better. And the contestants developed in that time specific evidence of widespread voter fraud, enough to account for up to about 4 times the deficit between the two candidates for president. And when we look at at fraud and what needs to be proved, and we can call some of this is just outright fraud. Dead people aren't voting of their own volition. It just doesn't happen. People don't accidentally submit 2 votes. And it's difficult to see how it would happen that somebody would innocently submit 2 votes. And some of them are perhaps we can call them more irregularities that should have been accounted for to make sure that the system had integrity, that it, regardless of the intent of the individual voter, regardless of the intent, it was improper for that vote to be counted. For instance, you only get to vote if you're a Nevadan. And that means a Nevada resident. And if you move out of Nevada, the statutes in Nevada have a very specific purpose of what you do. Now, I myself might feel like a Nevadan at this point. I've been lucky enough to be with Nevadans for the past almost 7 weeks of my life, which has been great. And it's been very gracious for this court to allow me to appear before it pro hoc vice. But I'm not a Nevadan. I'm a Virginian. And as much as I might rather pay Nevada taxes and vote in a swing state, I have to do that in Virginia. Just because people may want to vote in a swing state, and because they might have once lived in Nevada, and maybe they still have family in Nevada, doesn't mean they get to do that. So, regardless of whether they know that particular law or not, normally with fraud we go back to those elemental definitions where there's that level of intent that's involved. That is an improper vote. That is a vote that is irregular, that should not have been counted. That we have ways to make sure that the voter rolls are clean, to make sure that those people, once they have moved out of Nevada, are no longer voting in Nevada's elections. So this body of evidence, these data, this information that we have given and presented to the court, shows that there is a large number of sometimes outright fraud, and sometimes these irregularities, however you want to categorize them, that both result in the same outcome. They're votes that shouldn't have been counted. They shouldn't have affected the results. This is especially important because every time you have a fraudulent vote that is cast, an improper vote that is cast, you have just canceled out the vote of a legal voter. You've disenfranchised a legal voter. And the more fraud, irregular votes that are counted, the more Nevadan voters you've also disqualified them from voting, disenfranchised them from voting. And the facts before this court that happened in Nevada, not anywhere else, everything that we have that we can show that happened in Nevada, point to many, many thousands of votes that were improperly counted, which means many, many thousands of Nevadans whose votes were disenfranchised. Now, of course, much of the evidence of voter fraud is in the hands of government and election officials. And as I mentioned, we've had to do much of our work with using hard work, some elbow grease, and problem solving in order to get the evidence that we need without the normal civil discovery methods. As a litigator, it's been a challenge. It's been somewhat rewarding to think outside the box for how you get information to present to a court without being able to send out document requests and document subpoenas early, and interrogatories and take depositions all through a long period. We of course, in this case, we filed it on November 17th. Last Tuesday, the court gave us the green light to start the discovery process with the depositions. So we can, in almost all of our depositions, were of our own witnesses. The only subpoena that we ended up getting from an outside party returned for documents, I believe, one of the only ones was from the Department of Motor Vehicles. Almost all the other evidence is stuff that we were able to gather ourselves in that time frame, which was why it was particularly troubling that other evidence that we knew was there, it was hard to get in time to present to this court in a timely way, being the limitations of what we have available. We can't just go knock on the government's door and ask them for that information without some sort of legal tool. An example is that when the court gave us the opportunity to start discovery, we promptly got out a subpoena for the Registrar of Voters in Clark County, Joe Gloria. They closed and locked their offices so that we couldn't serve it. We tried to serve Mr. Gloria personally in his house. He spent several days avoiding service, knowing where he was, but we couldn't get actual service on him. While he was doing that, the deposition testimony will show, he was meeting with the defendants. He was working with them and putting together their case, where he was a government official that's supposed to be impartial, supposed to be ensuring the integrity of elections, was stonewalling the contestants being able to serve subpoenas. That's very unfortunate, and it goes to the problems that we see in this case and why it's so important that we have true transparency in elections, why it's so important that we have impartiality. The court is going to see, in Clark County, unfortunately that didn't happen, and we have one witness, I believe it's Doe 1, although I'll verify that in a moment, who says that Mr. Gloria was inspecting voting sites with a Biden pin, wearing a Biden pin. This is from a county employee, a whistleblower, came forward and gave deposition testimony in this case. It is difficult for the voters to know that this election has integrity when you have situations like that. Very, very unfortunate decisions like that. Where you have situations where we are in a very short time frame and have a problem getting the evidence that we need in order to bring it before this court, because people know that of that short time frame and think they can simply run out the clock. Nonetheless, even with that, we have given to the court the compelling evidence that we've given the court. Expert testimony from former Secretary of State Scott Gessler that into great detail into the failings of the election administrators, the problems with trying to administer a vote-by-mail system, the way it was done. Testimony from poll workers about the lack of any meaningful security for physical and electronic ballots. Data gathered and narrowed in less than a month, showing thousands and thousands of specific incidents of fraud and irregularity. Testimony from technical workers who manage the electronic voting machines that people cast their ballots on. And this is testimony, and again, that's Doe 1, right? Doe 1, the Doe 1 deposition is compelling, and we ask the court to pay special attention to it. The Doe 1 testimony shows, and it's supported by other evidence as well, that from another whistleblower, and more evidence submitted to the court, that you had no cybersecurity, no physical security on the voting machines, on these electronic machines that people went to cast their votes when they decided to vote in person, or when they decided to vote early in person, either on election day or early, I should say. And the fact that those discs, in each of these voting machines, you would put a USB disk. And that USB disk was not encrypted, didn't have security on it. And the voting machines themselves were essentially not password protected. And they were hooked up to laptops then where the laptops themselves could have been compromised. And in the middle of the night, what they would do is they would log these disks in and out. Good practice. And the disks had a specific serial number on them. And numerous times, a disk would be logged out with one vote total on it and logged back in the next morning during the early vote period with a different number on it. Sometimes more, sometimes less. What that means is that literally in the dead of night, votes were appearing and votes were disappearing on these machines. Now, we have tried extremely hard, and the court gave us an order earlier this week that allowed some inspection on the digital devices used in this election, to find out how this could happen. And no one can tell us how it can happen other than the fact, that we know that there wasn't any encryption on the disks. You would plug this disk into a computer and you could access all the votes on it. You could change totals, you could change columns for the voters. That much we know. And the unfortunate thing is, we can't have access to these machines in such a way that we can inspect them to verify that these machines are doing what they're supposed to do. Instead, the manufacturer of the machines rests on claims of intellectual property for the code and whatnot that they have. That's a problem. When it comes to voting, we can't have people hiding what could be malicious code or bad code. Maybe it's only accidentally bad, maybe it's purposely bad, behind intellectual property. Then having no way to be able to ensure that the results this machine is putting out has any form of integrity with it. So, we know the problem. We can't get to the exact solution because we can't get the full inspection. But what we do know with these machines, what we are sure about, what we have testimony to, is that in the dead of night, votes disappear and votes reappear without explanation. And there's no good explanation for votes being cast on a machine, on a disk that is unplugged from a machine in the middle of the night.
In reference to that issue, what evidence are you specifically relying on? Which specific individual, whatever? I'd totally like to know that.
Doe 1, Your Honor. Doe 1 testified about that, and that there is another declaration that we've submitted to the court from a separate whistleblower that supports that. The declaration is, what exhibit is the second one? It's Exhibit 62, which is in binder 4, Your Honor. Your Honor, we've also introduced testimony from people taking advantage of underrepresented communities. Evidence that shows that bad actors executed a scheme of incentivizing individual people to vote. going to some of the reservations in Nevada and incentivizing people to vote, where it was a very clear tit for tat. You had to show that you voted, and if you voted, you would get things like raffle tickets. And many people were getting cash cards, gift cards, televisions, more.
How many votes are we talking about there?
I thought it was like 500 when I reviewed the information, the deposition, and that. It wasn't a huge amount of votes, though, was it?
Your Honor, we don't know, because we haven't been able to get some of the exact discovery on the exact number of votes that were actually counted using that system.
Out of your information, 500. So
Correct. 500 is how much we've been able to. I believe that's right, Your Honor. I think that it's that number. And so that is, of course, some of our numbers are bigger than others. This is a particularly important one because it's at least 500. It's not something that would otherwise be in our care, custody, or control to come up with without more formalized discovery, but we do know what we've submitted to the court on that. That's in clear violation of the law. And in addition, the same campaign that was being used to I understand the wonders of modern technology. Thank you. The same campaign that was incentivizing people to come out and vote in violation of state and federal law, that same campaign was also directly involved in encouraging people to come out and vote for the Biden-Harris ticket. We, of course, don't have information that those people were paid by the Biden-Harris campaign, but it was still a part of show up and vote. We're going to give you something of value, and in several parts, sometimes the same part of the campaign, sometimes separate. Oh, also make sure that you vote for Biden-Harris. This is something that can never be able to stand in an honest election. We have evidence that is more direct when it's tied to the Biden-Harris campaign. Evidence from a whistleblower, Doe 3, of individuals at a Biden-Harris bus, and this bus was close to a polling location, an early vote polling location. And at the early voting polling location, as she was on her lunch break, she would take walks around the center on her lunch break. And as she was on her walk, she noticed unusual activity happening at the Biden-Harris van. She was a poll worker. She knew what ballots looked like. She saw people taking handfuls of ballots, multiple people, and filling them out on the side of the Biden-Harris van. Not one, not two, but multiple ballots being filled out. Everyone gets, again, exactly one vote. No more, no less. There is no reason why anyone at any place would be filling out more than one ballot. And for people to bring handfuls of ballots to one location where they're then, and there's also statutory requirements about when you can help a voter fill out his or her ballot and what you're supposed to do if you do that. In that case, Your Honor, the whistleblower circled back around again and saw them actually putting the ballots into the pink and white envelopes, which of course is the color that she's able to get close and see, that she would know because she's a poll worker, the return envelopes that people would use to return their ballots. You can never do that. There's never an instance where that would be an acceptable thing to do. She reported this. She reported this incident to her supervisor, who called the county, who called the people in the registrar's office, and they were told, oh no, vote harvesting is not illegal. This, of course, is not vote harvesting. Vote harvesting has its own problems, but the legislature has, in its discretion, decided to make it legal. This is vote planning. This is ballot box stuffing, pure and simple. There is never a reason where a person can fill out more than one ballot, and it was happening in this election. That takes us back to the data that we talked about and why the data is so important in this case. This is data that we got from Mr. Kamsel as an expert witness, that he was able to testify to a reasonable degree of certainty about what he does in his normal course of work in order to take and compare the list of people who have voted with other lists that are available, so we can actually see if the people are voted are people who are voting illegally. The numbers that came up with were striking.
You know, the defendants don't think that the
Counsel has the credibility or the qualifications to even testify based upon his lack of education, lack of statistical analysis ability, lack of publication, lack of other testifying, lack of, it goes on and on and on. So, again, there's an issue in respect to his credibility, under basically the Nevada law. Obviously, Nevada law would look at the Hallmark case and whether or not he meets the qualifications, even as an expert. I'm raising it because the defendants raise it a lot in respect to his testimony.
And it's certainly an important issue for the court to consider is whether he's an appropriate witness. And of course, using Hallmark, using the system that Nevada uses to qualify experts, there is always the difference about weight versus admissibility with experts. And it is not the situation where you can only put a college professor on the witness stand or someone in academia to testify as an expert. When it comes to expert testimony, you often look at the experience of the particular individual and what kind of experience the individual has had in coming up with these particular methods. And someone that has worked in data science and analytics for as long as he has is somebody that has that experience, that helps the court, is helpful to the court, not in giving legal conclusions. And much of the questions that they ask Mr. Kamsel are just legal conclusions, which of course would never be acceptable as expert testimony. But the method that he actually takes in order to compare one list to another.
He comes up with a lot of different numbers. I went through his numbers and looked at them and tried to understand them. Does he ever make a determination in respect to his numbers where he says X number of these votes would have gone to basically Donald Trump? He doesn't.
No, and let me explain why we can't do that.
Well, doesn't that become an issue, though, because it's very difficult because we look at the two-pronged test in regards to NRS 293.120, A, and then the different ones that you go through, and you have to be able to show the differentiation in respect to the votes. Sufficient a number of votes to get over, I think in this case, 33,596 votes. And he never says that, because I went through that deficit looking for that determination. He just says, these are the things that we think may have happened. We think these things happen that are bad. And I'm not saying he's not right or wrong. I'm just saying, at the end of the day, when you get done with this analysis, we don't know where those votes would have gone. Or if those votes went one way, they shouldn't have gone. There's no ability for him to make that determination reviewing his deposition. At least I took that away from his deposition.
If that were the standard, that you had to be able to tell which contested votes would go to candidate A and which contested votes would go to candidate B,
it would make any election contest impossible.
I don't disagree with you. It's just but that's part of the test.
I think that that's not exactly part of the test. Here's where I would disagree with the court on this. I think the test is whether there is enough votes that shouldn't have been cast that would span the margin between the candidates. That's what we look at, and that's because of secret ballot. It's also why, this is another reason why it's so important to have these protections on the front end. Why you have to be able to protect election integrity on the front end. Because short of an election contest that we're doing right now, there's no way to do it on the back end. To be able to tell X number of these votes would have gone for Joe Biden, X number of these, Y number of these votes would have gone for Donald Trump. Once a vote, there's two different ways in Nevada this year that votes are cast. They're cast on an electronic machine or they're cast in the mail ballot. Once the vote, if it's cast by mail, is taken out of its envelope, that is something we call separation. And because the envelope includes all the voter information on it. And what is supposed to be done then to provide for security is that envelope and that ballot never again will meet. They can never be matched back up to each other, because if they can be matched up to each other again, it's not a secret ballot. So once that ballot comes out of the envelope and it goes into the voter pool, if it's a poisonous ballot, it's poisoning the entire pool. And so, yes, there is no way for us to be able to tell which of these people voted for which candidate, because we hold the secret ballot so sacrosanct. But that's why you should not read the contest statute to be able to say that you have to tell how many bad ballots went for candidate A and how many went for candidate B, because if you do that, you make an election contest impossible. Mr. Kanzel's long experience, does allow him to identify specific voters to a reasonable degree of certainty. And he took his various universes and found that over 8,111 voters voted from fake addresses. 15,681 voters voted from vacant addresses and commercial addresses. This is especially important. This is these irregularities that we talked about. You can't do that. You can't vote from a fake address. You can't vote from a vacant address. You can't vote from a commercial address, because it has to be where you live, because that is where you are represented. You're represented where you live. 1,506 votes from dead voters. 19,218 votes from non-Nevadans. And particularly striking is 42,284 votes from double voters. That number right there is more than the gulf between Vice President Biden and President Trump in this case. Now,
You have about 15 minutes more to go.
I understand. I've run more than
You have 35 minutes. I just thought I'd give you a heads up.
Thank you, Your Honor, and I've also been made aware by my co-counsel. And I'm going to leave it. I'm going to wrap up
at this point, and then I'll be back for rebuttal. The double voting happens because the voter rolls aren't clean, and we have evidence that we've submitted to the court where good people, honest people, have taken that and say, look, I've got two ballots here. Maybe it's one in my maiden name and one in my married name. When you don't clean the voter rolls, stuff like that happens. Honest people do what happened here, in some cases bringing them to us, not voting them, destroying them, whatever it might be. But in a presidential election, perhaps this presidential election more than most, passions were high. People felt very strongly. And we have 42,284 instances of people voting twice. We have the poll that we've submitted showing that of the people who submitted mail votes, approximately 1% of those people say they didn't cast a ballot at all. Again, something that without the tools of a prosecutor, it's one of the few ways that we can actually test that. So people are taking other people's ballots, and there's been stories about that has happened where people are having their votes specifically stolen. And people, that may wish to abstain and not vote at all are voting because somebody else decides to vote for them. Your Honor, every single one of these instances that we've identified has resulted, again, in the votes of honest Nevadans being disenfranchised. The only thing to do with this, to avoid the debasement and dilution that comes with the vote fraud and irregularities, is to grant the contest and to strike the Biden voters from representing Nevada in the Electoral College. We understand that this is an unusual situation, but what we can't do is turn a blind eye to voter fraud. We're going to keep being the beacon of representative democracy of the world. When it goes bad, and here it went bad, we can't just turn a blind eye to it. That's not what we do in America. We make it right. We are asking the court to make it right. And the way to do that is to make sure that improperly elected electors don't represent Nevada in the Electoral College.
I reserve the rest of my time.
We're going to just take a short break, about 10 minutes. We'll come back and proceed on that, Jason. Thank you. Mr. Hamilton, don't go anywhere.
You have multiple machines there, and they're there for 2 hours. So you do the math. How many ballots went through those machines in those 2 hours when there was no one there to supervise, to be present, consistent with your statutes and rules, to supervise the tabulation? We believe that could easily be, and probably is certainly, beyond the margin of victory.
All right, if you haven't been paying attention, the court case is taking a short break to the time to play. This is part of the evidence from the Georgia hearing that Giuliani was at shortly ago. You'll probably remember the water leak. Basically what they're saying, and this is surveillance footage. There's more of it from the counting center in downtown Atlanta, which is the Phillips, the old Phillips. It's where the Hawks play. Hey, they got video, and it shows a woman come out, tell everybody we're done for the night, we're leaving. Everybody leaves, including all the observers and the media and everybody. 4 people stay behind. They continue to process ballots, and they continue to do things from approximately about 10 o'clock that night till 1 o'clock the next morning.
in this race.
So,
These machines can process about 3,000 ballots an hour. You have multiple machines there, and they're there for 2 hours. So you do the math. How many ballots went through those machines in those 2 hours when there was no one there to supervise, to be present, consistent with your statutes and rules, to supervise the tabulation? We believe that could easily be, and probably is certainly, beyond the margin of victory in this race.
there you go. So, we are going to wait for this feed to come back in. We definitely appreciate everybody at Right Side for their work to get these streams up. In this particular case, Right Side is restreaming NTD. If you're not aware, NTD is part of the same media network as Epoch Times, or Epic Times, which is a really good website. I've been using it a lot for research, and one of the draws is they source their articles a lot. Every other line has a link to some source material. And they have proper grammar, which is something missing from a lot of digital media. That courtroom sounds horrible. I mean, it's a mix of things. The defense attorney is zooming in on the TV on the wall. The internal microphones are horrible. And then there's just a bunch of random microphones streaming. So they shall return here in a moment. See if we can catch somebody in a hot mic situation.
That's basically him declaring, yeah. I actually suppose some stuff.
Omar, you're not correct. Fraud is a white-collar crime, and 90% of the time is charged civilly.
Well, we won it though, years ago. Check it out. If you look at the vote judges, all the legislators that we endorsed, we primarily endorsed, they all voted in power.
And yes, this is not a criminal case. This is a civil case. Criminal cases are brought by the district attorney on behalf of the people of the state, or city, or county. And yes, criminal cases do have a higher burden of proof.
He's a great guy to work for. Seems like that. I've been called all we gotta do is play around. I guess really doing nothing to work. You know, state court. Some of our tax forces, where's that?
How are we doing now? They got about 4 more minutes on the break. I actually read an article that said that this judge takes frequent breaks. I think they were alluding to his advanced age. Yes, the entire point of this particular situation is the state has produced a motion to strike, which basically, in this case, if the judge were to grant it, would kill the case. So basically, they've both been given an hour to plead their case. And here we go. We are back.
Thank you again. It's Kevin Hamilton. I appreciate that the court set 60 minutes per side for argument. Not to test that limit for the court's patience. On November 3rd, 2020, the voters of Nevada and the nation as a whole elected Joe Biden as president of the United States. In Nevada, the margin was 33,596 votes, as Your Honor noted. Those results have been carefully canvassed, audited, and certified by county and state officials, including the Nevada Supreme Court. 2 weeks after that election, on November 17th, the contestants filed their statement of contest, and the contest seeks breathtaking relief. An order from this court overturning the election and declaring President Trump the winner in Nevada and certifying contestants as the state's duly elected electors. Or in the alternative, holding that the November 3rd election be annulled and enjoining Nevada from certifying any electors from the state of Nevada, entirely silencing the votes and voices of 1.4 million Nevada voters in the selection of the President of the United States. It's difficult to imagine a more shocking and fundamentally undemocratic act than to ask a court to overturn the expressed will of an entire state simply because the contestant's preferred candidate didn't win the election. No court in the history of the United States has ever entered such relief. Now, one would imagine that any contestant seeking such unprecedented and breathtaking relief would approach this court cautiously. As the United States District Court for the Middle District of Pennsylvania noted just 2 weeks ago, one might expect the contestant seeking to overturn the results of a presidential election would come formidably armed with compelling legal arguments and factual proof of rampant corruption, such that the court would have no option but to regrettably grant the proposed relief despite the impact it would have on such a large group of citizens. Close quote. Not these contestants. It's difficult to imagine that even they take this claim seriously. From the start to the jumbled end, this contest appears to be nothing more than part of a larger extrajudicial effort to disparage hardworking state and county local election officials across the country and to cast doubt on the outcome of the election, all in service of some larger political agenda. Nothing about the contest even remotely warrants the relief the contestants seek. First, from the very outset, the statement of contest falls woefully short of satisfying the requirements of NRS 293-410, the raising cognizable grounds for an election contest. The claims relating to the Clark County use of the Agilis machine have been considered and soundly rejected by several different Nevada courts, including this court, and are thus barred by the doctrine of preclusion. And it's a claim that could and should have been brought long ago, so latches also bars the claim. And And none of the claims alleged in the contest actually fall within the very limited grounds enumerated by the contest statute. So the contest stumbles at the very courthouse door, and for that reason we moved to dismiss the case. But second, if the court even considers the contest on the merits, the closer one examines the claims and the supposed supporting evidence, the more the case simply falls apart. Contestant evidence on examination is built on nothing more than speculation, conspiracy theories, and a fundamental misunderstanding of the electoral process in Nevada. None of this comes close to satisfying contestants' heavy burden of proof. None of this is sufficient to overturn the results of the election. And none of this justifies the astonishing relief sought by the contestant. So let me start with the bases outlined in the motion to dismiss that we filed on November 23rd. First, to the extent that the contestants based the contest on Clark County's use of the Agilis machine or its failure to allow meaningful observation, both of those issues have been raised multiple times, fully litigated, and soundly rejected by this court. In Krause versus Sagatsky, the court considered these issues over a 10-hour evidentiary hearing, complete with live testimony from 9 witnesses and legal argument from counsel for the contestant himself, Mr. Pinal. Judge Wilson considered and rejected those claims in a thoughtful 14-page ruling. It's true he found a lack of standing, but those were alternative bases for his decision. And the contestants here as Trump electors are obviously in privity with the plaintiffs there, which was the Trump campaign and the Nevada Republican Party, and are thus bound by the decision there. So all the factors we've submitted for issue preclusion. But even if the claim weren't technically barred by issue preclusion because of the Krause decision, that decision is certainly persuasive authority for the proposition that nothing about the Agilis machine or how it was used by Clark County was even remotely improper. And indeed, since the election, 3 different district court judges in Clark County, Judge Atkin in the Rodimer versus Gloria case, Judge Sperman in the Marchant versus Gloria case, and Judge Hardy in the Becker versus Gloria case, as well as Judge Gordon on the U.S. Court of Appeals, the United States District Court for the District of Nevada, have flatly rejected similar claims. None of them have reached a contrary conclusion. Second, contestants' challenge to the Clark County use of the Agilis machine is barred by the doctrine of latches. The county's purchase of the Agilis machine was not a secret. It was reviewed by and even subsidized by the Nevada Secretary of State's office. Contestants could have and should have raised any concerns that they had about the use of that machine literally months ago, prior to its deployment in the county. Indeed, the county used the Agilis machine during the June primary. No controversy, no complaint, no issue. Contestants could have and should have raised any claims they had then, prior to the use in that election, or at the very least in the ensuing 5 months before the general election. But instead,
Hamilton, if you can hear me, we lost you.
Judge, the phone got disconnected.
Huh?
The phone disconnected.
The phone got disconnected. Can you hang on one moment? We'll hear you.
It was at this moment that he knew he fucked up. It was at this moment that he knew he fucked up.
Please enter your address, followed by the pound. To enable audio control, please enter your audio and followed by the pound.
epic.
Can you hear me?
Again, you're
Thank you. We can hear you again. If you can go back and start, I think you were kind of at the end of the Latches argument. Go ahead.
Right, thank you, Your Honor, and I apologize for the technical issues on it. Hopefully the technology gods will be with us for the rest of the argument.
Well, we aren't sure what happened, but go ahead. I apologize to you if it's on our end.
All right, thank you. The point is that the contestants sort of raised the complaint about the use of the Agility machine well prior to the general election and well before hundreds of thousands of ballots had been processed by that machine, allowing them to sandbag more than 1.4 million Nevada voters by waiting until after they voted and after the votes had been counted and certified by county election officials, and then asking this court in one judicial wave of the arm to reject them all is the very definition of prejudice. And so for that reason, the doctrine of lapses would preclude relitigating this claim again.
Under the Constitution.
And then finally,
Could they make findings?
They could,
the
of
claim
course.
fails for failing to comply with Nevada law. The Nevada election contest statute requires that the ground of the contest be alleged with sufficient certainty to inform the defendant of the charges the defendant is required to meet. That's NRS 293-410 sub 1. But the claims in this contest are anything but clear and certain. They can hardly be called anything but vague and undefined.
Well, let me ask.
The contest asserts very.
Can I ask you a question with respect to that? Obviously, if you look at Nevada Rules of Civil Procedure 8A, basically we're a notice pleading state. And I guess the question I would ask, I understand your argument in respect to sufficient certainty, but if we're a notice pleading state, if you go back and read the statement of claims, do I make correlation over to the Nevada Rules of Civil Procedure in light of the statute, or can I just look at the NRS 293.410, or don't I have to also look at basically the Nevada Rules of Civil Procedure a little bit to correlate things?
Well, Your Honor, of course, the Nevada Rules of Civil Procedure would be applicable to the extent that they're not inconsistent with the election statute. But election contest is a unique proceeding that's defined by Nevada law. And where the statute requires, calls out a specific pleading standard that is sufficient certainty, then of course that would trump, by the very Latin maxim counsel just described a moment ago, that would trump the generalized application of the Nevada rule. And the point here is because a Nevada election contest is such a short time frame thing, you don't bring this kind of a lawsuit unless you have the evidence to make a claim with sufficient certainty to inform the defendant of the charges. So it's not enough to assert categories. You have to name voters. And that's exactly where this complaint fails. It fails to identify even a single voter who, in any of these categories, who cast an unlawful vote. It fails to allege with certainty which voters voted twice, which voters voted after they were dead, which voters voted after moving out of state, or even for whom those alleged ballots were cast, or whether they even voted in the presidential election. Now, I'm just going to pause there. Counsel makes the argument that, well, golly, you can't prove that because the envelopes and the ballots are separated. That completely misunderstands an election contest, Your Honor. You're alleging an individual. John Smith voted twice. You have to name John Smith and prove for whom he voted. That's not impossible. In fact, in 2004, and 2005, there was an election contest over the governor of the state of Washington. It's a 2-week trial held in Wenatchee, were voters, in that case, all convicted felons who should not have been voting in the election. We took their deposition. Of course, you can ask them how they voted because they were illegal voters. They broke the law. They committed felonies by casting those ballots. So it's easy to do that. You just have to do it specifically because that's the only way this court has an evidentiary record to make a conclusion, to reach a conclusion that illegal votes were cast and for whom they were cast and by how many. And so there's a pleading problem at the front end of this case and an evidentiary problem at the back end. Let me finish on the front end. Having failed to identify specifically and pleaded specifically, the claim failed as a matter of pleading, and that is very part of a contest to action, and so the case should be dismissed at the threshold. But if the court goes on to consider the contest on the merits, the result's the same. The contest fails as a result of an utter collapse of proof. The contestant's case is simply a calamity, and the contestants barely contend otherwise. Ink is cheap, and contestants spill a lot of it attempting to make up their patent lack of admissible evidence with enthusiasm and overstatement. But their zeal rather dramatically outstrips their evidence. And in court of law, it's evidence that counts, not tweets or social media bluster, not hearsay or speculation. It's evidence, and that's what's missing in the record before the court. I just listened to counsel talk for the better part of 40 minutes with very few references to any actual evidence before the court. And so I think it's worth taking each specific claim in turn. The first is the Agilis machine. The contestants claim that Clark County violated the law by using that to sort ballots and verify signatures. That seems to be an invocation of NRS 293.410(2) sub F, which allows a challenge if a contestant can prove that, quote, there was a malfunction of any voting device or electronic tabulator, counting device, or computer in a manner sufficient to raise reasonable doubt as to the outcome of the election, close quote. Again, that's 410(2) sub F. This is not a new allegation, Your Honor. As I mentioned earlier, no fewer than 5 Nevada courts have considered this claim. Judge Wilson held that 10-hour hearing to explore it in Krause. Every court, state and federal, has rejected this claim without exception and without hesitation. And it's not actually all that surprising. The Agilis machine is widely used by some of the largest counties and metropolitan areas in the United States. Cincinnati, Ohio, Tallahassee, Florida, Pueblo County, Colorado, San Francisco, California, Salt Lake City, and dozens of others. Counties where Democrats are in charge, counties where Republicans are in charge, most importantly, counties where Americans are in charge. Contestants appear to raise 3 separate challenges to the machine. Each one is merit. First, they allege Clark County should never have used it at all, and that its use in processing signatures violates Nevada law. You heard that argument just a moment ago. That perhaps the easiest to dismiss. AB 4 specifically authorizes county elections officials to process and to count ballots by electronic means. That's section 22(2) of A bill. Second, contestants allege that the Agilis machine was properly utilized because they set the threshold at 40 rather than using the threshold setting of 50 that the machine is set on when delivered from the manufacturer. But that claim, too, has been thoroughly examined and thoroughly rebutted. First, and it's before you, the testimony of Jeff Ellington, the president and chief operating officer of Runback, the company that makes the Agilis machine. We took his deposition and transcript is before you. He testified that the company recommends that elections department the threshold set using a test deck of sample ballots to ensure that the machine accepts only obviously matched signatures. exactly what he did. Used a test deck of ballots to ensure that only obviously matched signatures were accepted and that all other ballots were rejected by the machine and subject to human use. The result is 30% of the ballots were accepted by the machine and 70% were reviewed by election department personnel. And maybe most strikingly, contestants' own expert mentioned just earlier in this very courtroom, Scott Gessler, admitted on cross-examination in his deposition that Clark County's use of the Agilis machine was entirely proper and even consistent with what he termed best practices. That's Heston's expert. Against that clear, specific, and undisputed evidence, contestants offer literally nothing. They stand empty-handed without any evidence to suggest that there was anything wrong with Clark County using the Agilis machine or how it was adjusted or how it was employed. But the claim simply failed for one proof.
Mr. Gressler made a comment in his deposition, something about to the effect that 40%, which is what Clark County used, was appropriate. Is that correct?
That's exactly right, Ron. In fact, he calls it best practice. The third attack on the Agilis machine relates to the Clark County database of exemplar signatures, which in some cases includes signatures from the Department of Motor Vehicles that were of poor quality. Specifically, the contestants contend that the Agilis machine requires images to be at least 200 dots per square inch, or DPI, and that the DMV signatures were only 100 DPI, and thus unreadable. So this fails for the same reasons, really. Mr. Ellington, again, the president of Runback, the manufacturer, confirmed that while it's true the Agilis requires a 200 DPI signatures to match a signature, he testified that if the machine couldn't read it because it was a poor quality exemplar, then it rejected the ballot, which means it defaults to human review. He emphatically testified that the Agilis would not match a signature when the exemplar was low quality. And Mr. Gloria testified to the same thing. If the Agilis machine couldn't find a high quality image against which to match the signature on the envelope, then it would reject the envelope for human review. And again here, contestants have no contrary evidence. There's no countervailing expert, no technical operator, no other counties or states operators testifying that something was amiss here. Nothing but bald allegations and speculation. They offer hearsay evidence from people who thought that certain signatures looked strange. And I don't doubt that people could have differences of opinions about signatures, but that's not enough by a far cry to sustain contestants' burden here. So the Agilis machine claim fails from start to finish, top to bottom. There's simply nothing there. And that, of course, is why every court to consider the claim has rejected it without exception. So whether you consider the case, the Krause case, to bar the claim for issue preclusion, or you bar the claim based on the failure to raise it sooner, you look at the merit, there's simply nothing there, Your Honor. The next category of claims advanced in the contest is legal improper votes. Under Nevada law, an election can be contested on the grounds of, quote, illegal or improper votes that were cast and counted, or conversely, legal or proper votes that were not counted. And in either case, equal to or greater than the margin between the contestant and the defendant, or otherwise in an amount sufficient to raise a reasonable doubt as to the outcome of the election. That's NRS 293-410-2 sub C. And Your Honor, this is where the wheels truly come off the train. Plaintiff stands before the court with no evidence of any illegal votes, much less evidence of which voters they contend cast those ballots, or even more fundamentally, for whom those ballots were cast. They fall far short of demonstrating 33,596 votes, the margin. There's no evidence to support allegations, no specific evidence, no specific voters or ballots, no knowledgeable witnesses with relevant and admissible testimony, expert or otherwise. So first they contend in the contest that same-day registrants were permitted to register by providing mere proof of Department of Motor Vehicle appointments rather than photo ID, or were allowed to cast provisional ballots even if they couldn't satisfy voting requirements, or that provisional ballots were counted even if not cured, or that mail ballots were counted from voters who didn't cast them. But there's no evidence to support any of that. The contestants offer a handful of witnesses to support the claims, but they largely concede in their depositions that they can't, that it's speculation. Doe 3, for example, testified that voters who only provided proof of DMV appointments were given provisional ballots, and conceded that she didn't know how many ballots fell in that category, whether those ballots were counted, couldn't identify the names of those voters, couldn't identify whether those voters had voted in the presidential election, or for whom those ballots didn't count. Doe 2 testified that some signatures looked suspicious and questioned out-of-state ballots, and felt that supervisors had unrestrained access to ballots, but agreed, in her words, in her deposition under oath, it's all just speculation. Doe 1, which was mentioned a moment ago, I would encourage the court to read that deposition with particular attention to page 66 and page 77. Page 66, Doe 1 admits that there's no evidence of any difference between the paper audit trail and the vote totals on the machine. At page 77, Doe 1 admits that he's not aware of anyone tampering with any of the USB drives. The contestants allege that no less than 500 provisional ballots were counted without the issues that rendered them provisional having been resolved. But they provide no evidence that this actually occurred. You, Your Honor, and I, and members of the public are left to guess who these 500 voters were. Joe Glory was asked about that allegation in his deposition. He specifically denied it. That absolutely not. Provisional ballots were treated in accordance with the rules, and only those that meet the requirements of Nevada law were counted. So that's the specific evidence that they come forward with, and it fails rather dramatically short of the mark.
Let me ask you.
They then fall back.
Let me ask you one question. One of the things that they raised in their brief was that Joseph Gloria made a statement to the Clark County Commission on November 16, 2020, that his staff discovered discrepancies that we cannot explain and cannot remediate without a recount. Are you aware of that statement?
I am, Your Honor.
Can you explain that in the context it was given, or maybe it's taken out of context? I found that interesting.
It is, Your Honor, you know, the truth of the matter is, and it's not unique to Nevada, it's not unique to 2020, and it's not unique into a general election. Every election will have minor anomalies and irregularities that just happen. So it's not like counting a universe, when you're counting a universe of 1.4 million ballots, there are instances in which there are minor discrepancies in the numbers. For example, in polling places, you know, in the United States, we rely on the volunteers and temporary workers to staff our polling places. That's how we do it. We don't have to do that. We could have a federal election organization, but in the United States, historically, we've relied on citizens to come forward. And a lot of those people work long, a lot of those people are retired. They're your father, your mother, your uncle, your brother. Those are the people that run our polling places, make our democracy work, and they work long hours. And at the end of the day, they have to fill out ballot accountability how many were spoiled, how many were voted. And you know what? Sometimes they make mistakes at the end of a 14-hour day. Those are the kinds of discrepancies Mr. Gloria was referring to. Those are the kinds of things that happen in every election. But they're, you know what? They're not proof that anybody voted illegally. That's a much more serious allegation, and it requires much more serious proof. So Mr. Gloria's statement, I think, is being blown way out of proportion for what it actually was. Did I answer your question, Your Honor?
Yeah, thank you.
The second way they approach this is with expert testimony, and particularly Mr. Kamsel, and they use a sort of a broad brush category approach, or Mr. Kamsel refers to them as universes. Universes of ballots improperly counted. So we tell people, well, Your Honor, there's some background, I'm not sure what that is.
We don't care. You're fine.
Okay. Mr. Kamsel's analysis collapses upon even minimal scrutiny. He is hardly a creditable expert. As I mentioned earlier, he spent his entire career as a political operative for the Republican National Committee. Admits that he didn't actually perform the data matching upon which his analysis depends. He doesn't know the rate of false positives. He doesn't know the error rates revealed in that exercise. He claims that he validated but didn't supervise or direct those efforts, and has no idea what that work demonstrated or the error rates they uncovered. And it's based on that testimony that contestants claim that thousands of Nevada voters committed felonies, voting twice, voting illegally after moving out of the state, or cast ballots in the name of dead voters. But Mr. Kamsel's analysis doesn't begin to prove that. For starters, Nevada voters who move out of state but maintain their residency are most certainly entitled to vote in Nevada elections. College students, for example, military personnel, citizens seeking medical treatment out of state, citizens assisting agencies in times of need, citizens spending winters or summers in vacation properties, serving in Congress, or living temporarily out of state for a million other reasons. Mr. Kamsel can't control for any of that, and he doesn't, and he admits it. Voters who passed away obviously can't vote unless they cast their ballot prior to their death. But Mr. Kamsel offers the court no evidence with respect to the date of death of the voters he identifies here. More fundamentally, he doesn't in fact identify even a single voter whose ballot was cast after he or she passed away. Not one. And he claims that there are thousands. You'd think he would attach them to a declaration that he would come forward with a report that he'd name even one. The same is true of Mr. Kamsel's allegations of voters who voted twice. He didn't do the critical data file matching, can't testify to the match rate, the false positive, or the error rate. This is precisely why courts across the country have routinely rejected this sort of slipshod analysis as patently insufficient in voting rights and voter registration cases. This is the ones I'm familiar with, Your Honor. I dare say that in an intellectual property or technical case, Mr. Kamsel would never be admitted as an expert. But perhaps most fundamentally, the contestants nowhere identify these supposed thousands or even tens of thousands of illegal voters. They allege in their statement that 15,000 Nevada voters voted both in Nevada and in other states, but they don't identify a single one. I go back to my very first point, Your Honor. This is a failure to identify with certainty. They identified a specific voter, sure, then the defendant or anyone else could go at that voter and determine whether they in fact had cast a ballot in 2 different states. A categorical accusation doesn't make proof in court. alleged that 500 votes were submitted at polling places by individuals other than the proper voters, again, without identifying a single one. They alleged that letter carriers violated USPS policies by delivering ballots to homes where voters didn't live, but they don't identify any of them. Your Honor, this is trial by allegation, not proof, and it falls far short of the heavy burden Nevada law places on those seeking to contest the outcome of a certified statewide election. Voting fraud in the United States is thankfully vanishingly rare, as Professor Herron testified. Yet contestants stand before you and boldly allege the wildly implausible that over 42,000 Nevada citizens committed felonies by voting twice in this election. 42,000. You'd think that anyone leveling that sort of a charge would have powerful proof. But contestants don't. They can't even name them, or perhaps they don't want to name them because of fear of liability of accusing somebody of a crime is obviously defamatory. They can't prove that any of those individuals even voted in the presidential election, and they certainly can't prove for whom those ballots were cast. This is an utter failure of proof on every level. Charitably, one might call it junk science, unreliable on its face, and offered by an expert who is no such thing. But even taken at face value, it fails to prove that which Nevada law demands, that illegal votes were counted in an amount equal to or larger than the margin between the candidates. So again, the claim fails for want of proof and should be dismissed on that basis. The third category involves allegations of misconduct by the Biden campaign itself. Contestants suggest that various groups or individuals affiliated with the Biden-Harris campaign engaged in misconduct, but they provided prove that allegation. Doe 3, for example, claims, and you heard a rendition of this just a moment ago, that unnamed and unidentified individuals gathered around a Biden bus in a parking lot of a polling center in broad daylight to engage in ballot stuffing. But in addition to being patently ludicrous, that witness admits to having no idea of whether these supposed votes or ballots were ever cast, let alone counted. That admission is devastating to this claim. And the contestants point to the Nevada Native Vote Project, which undertook voting drives this year, and argued that the Biden campaign bribed voters. But the only link they have between that group and the Biden campaign itself are masks, t-shirts, and signs. Is not implicated and is not responsible by anything a supporter does while wearing his or her t-shirt or hat. And in any event, or maybe the most fundamentally, they offered not a single witness who observed this event or could authenticate their photos. Not a shred of evidence to suggest that anyone was offering anything of value to manipulate a vote. And not a single thing that would indicate those individuals were acting on behalf of the Biden campaign. The entire allegation is simply a meritless attack on an organization that promotes Native American voter turnout without any basis in either fact or law. The last category, Your Honor, claims that involve acts of malfeasance or potential misconduct. And again, Nevada law allows a contest on the grounds that, quote, the election board or any member thereof was guilty of malfeasance, close. That's NRS 293-410 sub 2A. There's no evidence to support this broad and entirely unwarranted attack on Nevada's hardworking election officials. First, the contestants claim they were not granted meaningful observation opportunities, but they utterly failed to demonstrate this was willful misconduct, much less anything more than routine regulation of observers during the canvassing of an election. And regulation that was particularly important during a raging local pandemic. That's precisely why Judge Wilson in the Krause case rejected the same claim. And the only other allegation of malfeasance is use of the Agilus machine. And that fails for the same reason mentioned before. counting ballots by electronic means. This isn't malfeasance, Your Honor. This is nothing more than regular, routine, and professional administration of this election by Joe Gloria and his team at Clark County and all the election administrators across the great state of Nevada. Mr. Gloria is one of the most experienced and highly respected election administrators in the entire country. So let me just wrap up and I'll stop. Last week, the Third Circuit wrote, voters, not lawyers, choose the president. Ballots, not briefs, decide election. That's not something that a court should have to remind litigants. But since the election 1 month ago, we've seen the same pattern all across this country. Baseless lawsuits filed by plaintiffs who simply cannot accept the fact that their favored candidate lost the election to Joe Biden. But that's the decision the people of the state of Nevada made and are entitled to make. And that's a choice that can only be reversed or thrown out by this court on the very most powerful of showing with clear and overwhelming evidence of widespread fraud, malfunctioning machines that in fact distorted the true and accurate vote totals, or proof of official malfeasance. Simply put, breathtaking relief demands breathtaking evidence. But contestants stand before you with nothing of the sort. This court has indulged contestants at every turn, allowing 15 depositions on extraordinary court notice, compelling examination of sealed election materials, entering protective orders allowing witnesses to testify anonymously, and otherwise largely allowing contestants free range to collect whatever evidence they wish in whatever manner they sought. It's now clear that despite this flurry of last-minute activity, it was all for naught. Contestants are bereft of evidence to support their outlandish claims, and instead they offer hearsay that even on its face doesn't support their claims. They offer big numbers, but without support, without names, and without proof of any specific illegal ballot being cast. Not one. None of this is remotely sufficient to justify this contest, much less the jaw-dropping invitation to this court to overturn the expressed will of 1.4 million Nevada voters. This election was fair, the votes were counted correctly, and Joe Biden won. It's time for the contestants to accept that, and it's time for this meritless case to come to an end. So with respect, Your Honor, defendants ask this court to dismiss the contest without further proceeding, to enter judgment for defendants so that Nevada may have its voice heard when the Electoral College meets to vote for and elect the President of the United States. Thank you for listening, Your Honor, and thank you for allowing me to appear remotely. I appreciate it.
Mr. Knopf, I think you have about 10 minutes.
Your Honor, could I ask the court just for some indulgence for another few minutes to put together our reply?
As long as we don't lose Mr.
Hamilton, go ahead and take a short break. Thank you.
Thank you very much, Your Honor.
Take care.
All right, I'm going to see what else is available real quick. Not ready.
I can see that, and most of the RNC people look pretty shell-shocked, so they were easy to pick out.
Okay. Thank
There
you.
was not too many.
Okay. Senator Heath?
Just curious.
All right, now we're back in Georgia.
You know, if the legislature is called on to conduct further investigation to make a statement of fact, do you have a photo that would somehow
Of which part?
validate that you were, in fact, on the floor in Fulton County? I mean, I don't doubt what you're saying, but if we were
so-
really going to pursue this, can you prove to me that you were there?
Yes, I took several photos.
Okay.
And, yes.
Thank you.
And a reporter actually filmed me there, too, so.
Senator Gooch?
Quick question.
Do we have video? Security video as well, and then there was somebody who was recording, and I was in several recordings. Sorry.
You may have answered this, and I wasn't hearing you. While you were on the floor, did you see anyone from the Secretary of State's office?
No.
No state officials?
No, not that I was aware.
Okay.
And this is actually my first time giving this statement because I had reached out to several different people, called hotlines, submitted my affidavit, and no one seemed interested.
Have you written a letter to the Secretary's office?
I have not. I called the hotline. That's what I was told to do.
Okay. No emails?
I've sent several emails to different people, and this is a notarized affidavit that I got.
Thank you.
Okay. Yeah, we got it. All right. We'll get your contact information. I mean,
Sure.
we have that, so thank you.
Absolutely. Thank you all for having me.
Appreciate it. Thank you for being here. All right, our next is Annette Jackson.
Thank you.
Thank you.
Oh, I got a sliding podium. Good evening.
Yes, ma'am.
Gentlemen.
If you would just, again, give us your name and where you're from, and then let's try to get to the essence of what we're going to talk about.
Oh, my God, you're going to cut my time short, okay?
Yes,
I'm going to
ma'am.
make it move,
Make
okay?
it move. That's right.
My name is Annette Davis Jackson, and the reason I come before you, the Senate body, is I was a candidate for United States Senate. You can clap. Come on, clap for me. Just a little bit. Just a little bit. All right? So I was a candidate for United States Senate, and then I was pegged by Washington, D.C., Donald J. Trump Foundation to be a monitor in Gwinnett. I submitted a complaint form to the Gwinnett County voter elections and an email to Senator Ligon to include having a question on the military votes being duplicate. This is what I care about. There's a lot of things that I care about. But when I went to ask the Gwinnett County officials, where is the military vote being counted? They were a duplicate section, and of course there were two people counting the duplicate section. And I said, well, what do you mean by duplicate? Shouldn't the military personnel have their own category? And they said, well, they're in duplicate. What they did, they accepted military votes two ways, by absentee ballot and by email. When they got the absentee ballots by email, what they did was they printed out the email. They took another absentee ballot and stapled the email or the absentee ballot together. And then they bubbled in their answers. Who knows what it is, you know, on the amendments or anything. We don't know. I have this, and I'll leave this with you. If you go on the back page, I'm really technologically skilled, and I asked for the general election report, the summary report. In Gwinnett County, they had election day, advanced voting, absentee by mail, provisional, and the provisional for Donald Trump was 274. Biden 407, absentee by mail, Donald Trump 40,396, Joseph Biden 81,502. The advance voting for Donald J. Trump 90,472. The Joseph Biden 124,125. On election day, they had 35,271 votes for Donald J. Trump, and then Joseph Biden had 35,793. Now, for the total registered voters for this voting period, they had 416,458. 416,458. When you add up all the totals for all of these categories, it added up to 414,192. Now, the registered voters who voted was 416,458. So there's a margin of error. How I knew one margin of error in Gwinnett County was they counted the ballots 3 times, and they were short 30 votes. So what the election officials told them to do was scratch out the number that you had and put the number that you counted. So there was 30 ballots just on one that didn't have anything there. Then the precincts reported was 156 out of 156. That means the precincts were at 100%. The ballots cast were 827,758. I said before that the registered voters were 416,458 out of 581,467, which is a 71.62 margin. So I asked 827,000. Wait, where'd that come from? 758. They said that was page 2 of the ballot. Page 2 of the ballot. So I'm like, no, there's only one ballot, but they had a second page. So you have to question that 827 and what did you count as ballots and what did you count as amendments or whatever? We have no idea. So if you go to my statement for the violations, I do consider it as being fraud, and I also supplied a copy of a report that I submitted, and I'll show you guys here. I did 2 reports. One report was on the elections form, right? So I didn't depend upon the GOP portal. I reported 3 days in a row, 4 entries each, so I reported 12 entries each that went into a portal, so you might be able to get that copy too. But what I did notice is that a lot of the locks on the bins were broken. And so a lot of the locks on the bins were broken, so there wasn't the proper security. So I stayed within one bin to see, what are you going to do with this lock? So they said, we're going to have to go outside. These are old bins. We're going to go outside, and we're going to get another one. I'm going to stay here. But then I looked at the scanner or the rubric as to all the precincts with the batches that are supposed to be a part of that bin. What I noticed that there was one precinct, and then down at the bottom that hadn't been checked red. What I found out was they didn't know where that precinct was. It wasn't in the bin. Where was it? It was in panel review. I didn't find that out till the next day. So here's what I asked. I asked that please make sure that all precincts are counted before one considers the box complete and takes it away. The way that they considered in Gwinnett the box is complete, they put it over in another area near where they tabulate the votes, and they put a green sticker on it. So a lot of the precincts had not been counted, but they went over to the green area as being counted. And I did put down the precinct numbers, precinct number 137, batch number 7, total scanned was 50, and a clerk didn't know what to do with it. Another set of voters, absentee ballots had a red void stamp on it. And I'm like, where'd they get the void stamp? But they were unattended. So I made a copy of a complaint too. So I don't know, I'm probably the only one who did complaints, and use their own complaint form. Hallelujah on that one. So that's what I noticed. I noticed that there were more Democrat monitors on the floor than Republican. We follow the laws. They had to issue a statement to say, only one monitor per 10 tables, but they were flooded. Another thing I want to look at, and I think that points to the fraud, is Donald Trump did an executive order. He did an executive order regarding the establishment of task force on market integrity and consumer fraud. He did that on July 8th, 2018, and I'm wrapping up too. really quick. He said, by the authority vested in me as President of the President, by the Constitution and the laws of the United States of America, and in order to strengthen the efforts of the Department of Justice, federal, state, local, and tribal agencies to investigate and prosecute crimes of fraud committed. This is just not a civil issue, it's a criminal issue. Against the United States government or the American people, recover the proceeds of such crimes and ensure just and effective punishment of those who perpetrate crimes of fraud. It is hereby ordered as followed, and this is voting fraud. And he got together the Deputy Attorney General, the Associate Attorney General, the Assistant Attorney General, the Assistant, and the Tax Division, the Civil Division, the Criminal Division, the Antitrust Division, the Federal Bureau of Investigation, the attorneys designated by the Attorney General, and the Department of Justice. He did such a fantastic job in bringing out fraud, and this was in 2018. So how could he and his lawyers, Giuliani, as well as Sidney and Lynn Wood, bring fraud to the case? Because they knew that there was going to be fraud 2 years before the fraud existed. And not only that, he brought in the Secretary of Treasury, the Secretary of Defense, the Secretary of Health and Human Services, the Secretary of Housing and Urban Development, the Secretary of Energy, the Secretary of Education, all across the board. I know, I gotta go.
I
gotta go.
I need to get 2 more people, and then we're going to have to wrap it up.
Okay, 2 more people.
I appreciate you.
But here's my statement.
We have your statement, right?
You have my statement right here?
And if you could leave it right here.
I will definitely leave it right here. Gentlemen, thank you so very much. I appreciate it. So I've submitted all the forms.
Yes.
Thank you very much for what you do. And there was fraud, and it's the election. My name is Annette Davis Jackson, and I was a candidate for U.S. Senate.
Thank you. All right.
And I hope you decertify and hold a session for all of the General Assembly. Thank you.
I'm going to call Scott Hall, and then Nancy Claire, and then we're going to have statements by some of the senators, and we'll be closing out. Thank you. Mr. Hall, we're running short on time, so just tell us where you're from and just tell us what you saw and what you're wanting to bring to the attention of the committee.
Not a problem, Mr. Chairman. Many of the members here probably know me. I've been around this Capitol since Tom Murphy walked the floor. And I've been knee-deep in this situation for the past 3 weeks, so I'm going to get right to the meat of the issue. Is there something wrong here? There abso-damn-lutely is, okay? And I have seen it. I am knee-deep in it, top to bottom. Number one, I was there on the first recount. There were large quantities of what appeared to be mail-in ballots that were not marked by a writing instrument, period. They appeared to be marked by a printer, okay? Pure and simple. You've heard that.
What county were you in?
I was in Fulton County.
Okay.
I was at the Georgia World Congress Center.
Okay.
Okay. And we saw this over and over and over again. I have prepared testimony that I can submit. I have photographs. And during the second day of the recount, we in fact, again, 99% of the people that in fact had left, okay, you had a very guarded area that had tape and ribbon around it where they monitored the bags going in and out. And then at 12 o'clock on Sunday, okay, 12 o'clock on Sunday, everybody's gone. They set up 2 tables. I have photographs in the lunch area, which is outside the viewing area of the security cameras. Again, I have security, I have video, and I have photographs. People were asking the number of monitors. We were limited to 1 monitor per 10 tables. 1 monitor per 10 tables.
I want to stop you, right? I want to ask you one question. Are you saying that a table was set up in a lunch area that was unsupervised and ballots were counted?
Yes, sir. And I got a picture.
Okay.
Okay. And I couldn't find it looking at the security cameras.
Okay. All right.
Okay. So I'll continue. Again, then one of the people that I've asked from the Secretary of State, I think, nominated a Fulton County monitor by the name of Carter Jones. Again, we're getting these calls at ridiculous. I got a call at 10 o'clock last night saying we're counting again at Fulton County. I had to run down there to Fulton County, Georgia World Congress Center at 10 o'clock at night, okay, when there's virtually nobody around. Okay, and I meet Carter there, and we start talking about the issues, and he said, I've already filed 3 reports, and this is going to be the 4th. And I've asked twice, but I haven't seen a copy of those deficiency reports from Carter Jones, who's the Fulton County monitor. So I can tell you, I also monitored the Fulton County warehouse on English Street. I was there. I, in fact, actually bought lunch for everybody there. Fulton County employees there were wonderful, okay? But I cannot say the same for the contractors, okay? I don't know who these people are that they brought in, okay? But they ain't from Fulton, okay? And I heard Bridget Thomas talking about somebody doing something with cards. I showed them a picture, okay, of the guy we brought in lunch, okay? Fulton County Warehouses trying to escort me down to the lunch area. The same guy comes out, and that was the only area that was off limits. You weren't going back there. Okay? I don't know why the lunch area was more secure than the area that they do everything else. One thing also I learned is every thumb drive, every vote in Fulton County is reduced to a thumb drive. Every precinct carries those to one of 4 locations: North Annex, South Annex, Roswell, and downtown. Then they carry those thumb drives to English Street, okay, where I have photographs of pallet loads of basically signed checks, okay, pallet loads. I have the photographs, every possible precinct. So you've got every single vote, okay, you've got currency, okay. Now you just need somebody to do it. I hired one of my guys to basically go out and say, guys, can this be done? Could you, in fact? Now I've got all the votes that haven't been uploaded anywhere. And he actually wrote me a paper. And he said, it's the stupidest, simplest thing I've ever seen. He said, Dominion's own documentation shows how you take an entire batch, swipe it off, and then swipe on a new batch before you put it into the real-time reader that uploads. Okay? I got up this morning, okay, and cried, okay? I literally cried. I've got just as many friends on the Democratic side of the aisle as I do the Republican. And I feel like I've got Alabama and Auburn playing football. Alabama won by a nose. Auburn goes back and reviews the video, and they say, you didn't quite make it. And they're saying, you're just mad because you didn't lose, or you lost. And I said, no, I think you're cheated. When in reality, somebody paid the damn referee $1 million to, in fact, call this game. Okay? I have been knee-deep in this for several weeks, and there's no question in my mind something is very wrong, and now you've got video proof. Okay? You've got video proof. And then Bridget talks about what was going on at the Georgia World Congress Center. Okay? And I see the very same guy that, in fact, tells me I can't go to the lunchroom. Okay? And then I go to the Georgia World Congress Center, and I, in fact, document a defect. There is a sea of these bags that they were so careful about having these red security tags on. Me and one other individual noticed 9 bags. 9 bags. It's in my statement. And I, in fact, called over Georgia World Congress Center security and the Fulton County, and I said, guys, I'm a monitor. I need to document this defect, period. I am in an area outside the ribboned area. They wouldn't let you take photographs. I don't know why we were so concerned about, you can have a camera 7 miles away, but we can't take a photograph of a problem. I was outside the ribboned area. I told the officers, okay, I said, see all the security tags? Here's one missing, and there's several others that are missing. I'm going to document it. You know what they did? They kicked me out of the Georgia World Congress Center. Okay, I've got proof of that. Guess what? The TV station wanted to know what happened. I sent them over there. They recorded it. Me and one other did. They did not, for some reason, want me to document what I was there to document. Okay? An election bag that was missing a security tag. I ask any one of you, you put your luggage on an airplane with a lock on it and you get it on the other end, should you be suspicious? You're dead burn right you should be suspicious. So again, you know, it is breaking my heart. The more that I dig, the more that I find. Again, you know, I got friends on both sides of the aisle, and you know, this is wrong. This is very wrong. I'll be glad to take any questions, but somebody needs to get a list of those contracts. You know that one individual, I asked 3 times, is he a Dominion employee? Is he a Fulton County employee? One time, yes, he's a Dominion. Next time, he's Fulton. Well, it just so happens that he, in fact, was a Dominion employee that was recently hired by Fulton County. And that should raise flags.
Thank you. We're going to take one more witness, Miss Nancy Kane. Thank you for coming.
Absolutely.
Mr. Hall.
Thank you, John. You guys testimony?
Yes, we've got it. Yeah. And if you just state your name and where you're from, and then give us a brief statement of what you
Certainly.
want us to know.
My name is Nancy Kane, and I have lived in Georgia for 20 years. Let me just tell you, I've been an administrative assistant for many years as well, and I'm a linguist, a Spanish linguist. I volunteered to be a poll watcher, just want to say this briefly, at the general election in 2020 because I saw it as an opportunity to give back to my country. For me, as a law-abiding and naturalized citizen of the greatest country in the world, it is my duty and an honor to help ensure the integrity of our most sacred right as Americans, our right to vote. So let me just tell you, I lost my job because of COVID-19, and I saw it as an opportunity also to fully be engaged in this election and do my part. So I started working as a poll watcher at the advanced voting at the Lower Roswell Road, Marietta location. I was also a poll monitor during the processing of absentee ballots, and a poll watcher on election day. So let me just tell you what I observed briefly, and what raised flags to me that something was wrong as well. Around 10 a.m. on November 5th, I arrived at the State Farm Arena, Fulton County Board of Elections, to witness the vote counting of absentee ballots. Upon arrival, I was not asked to present my credentials, but I identified myself. I was told where to sit, and I sat on a table right in the media cameras, and everybody was right behind me. Shortly thereafter, I just noticed to my right, a young man just with a paper ballot punching in the selections on the ballot on a voting machine. I go, how strange is that? Why not put it through the scanner? So I asked the supervisor, what is he doing? Can you explain to me? And he said, sure, what we're doing right now is after the military ballots are transcribed on a proper format, or ballots that come in damaged, we try to salvage those, he says. So we're just, transferring them to a new ballot, and then this is the process, this is the procedure that we're doing. So it's still very strange to me that it would not be put through a scanner, because when this young man was doing that, nobody was verifying what he was doing behind him. So technically, he was voting for someone else on a voting machine, but nobody was, trying to verify what he was doing. So I took video and I took pictures, and I also recorded my conversation with the supervisor with that explanation. I also told them that I noticed that none of the people there had credentials on. And he said, oh, many of them don't have. And that's my brother right there, the one that was doing the voting for someone else. It just seems so out of not following protocol to me, I left shortly thereafter when I heard that the counting was over, the counting of votes was over. So I went to DeKalb County facility. And when I got there, again, I identified myself to another poll watcher who walked me around. This was a very strange facility. All the rooms were whatever was happening there was segregated, and behind closed doors. And I saw that the poll watchers were many feet away from what was happening, not able to observe closely. And I was in the room where the scanners were and the poll watchers were, and 30 feet away. How could they possibly see what's going on? There was another table where they were duplicating the votes, the military votes. And I asked, why are you duplicating those? And I understand that some of the military votes, they vote online, so they have to be in the proper format. Okay, again, nobody was looking at that close enough, to see if they were doing it correctly. I spoke to my fellow poll watchers, and they were very frustrated that they were not able to see. An attorney for the city came to me and said, you need to move. Maybe because I was too close to where the scanners were, behind these glass doors. And so I said, well, I've been a poll monitor, I said, and I was able to move around, walk around. And why is it that the other monitors here or poll watchers are not able to do the same? And I showed him the statute of Georgia that says that we're able to do that. So he looked it over, and came back with some tape, masking tape or some sort of blue tape to put mark on the floor next to the tables where we could then stand and observe closer. But again, this was 2 days after, right? A lot happened before that we were not able to see close enough. So that's what happened. That's what the major observations for me is just appalling, really, what's happened. And I just want to say I'm heartbroken, hurt, appalled, angry at the level of fraud and irregularities that we are witnessing in this election, and especially ashamed that this is happening in the state of Georgia. I ask you to please do your job as elected officials, the job that we have entrusted you to do, and ensure the integrity of the vote for the American people, who on November 3rd, we look forward to casting our votes. Because as of now, we feel completely disenfranchised, and it is as if our vote did not count, was nulled. And I know I speak for the 74 million Americans who voted for Donald J. Trump, the best president this country has ever had. And I'm proud of my country, and I'm speaking from my heart. And what is happening in our country is a travesty, and we cannot allow it. We cannot accept it. So thank you so much for listening to me today and to all of us. Really appreciate it, and I hope that you do the right thing.
Thank you so much for being here. We appreciate your time. Okay, I know that there are some senators that would like to make a statement or two, and I'll allow that, and then we'll close it out after that. So, Senator Parent, I know you wanted to say something, so I'll recognize you now.
Thank you. I'm number 6, am I on? Yeah.
You're on.
Thank you very much, Mr. Chairman. Well, colleagues, I sort of feel like where I sit that it's kind of like an Alice in Wonderland moment where you've gone down a rabbit hole, and through the looking glass, everything gets wavy and seems really confusing. But to me, that seems like a sort of alternate universe that we don't have a lot of evidence of, frankly. And there's a lot of misinformation or misstatements even being disseminated by some witnesses, probably in good faith. But when you investigate further, you realize that this is really not a surprise, because if you've read the affidavits that have been filed with a lot of these lawsuits, what you will find is that people see things that they think are suspicious, but they do not understand the elections process in Georgia. And once that gets investigated, you find out that what they have actually seen are things unfolding the way that they should be. And I just would like to mention just a couple of those things. First of all, in the video that we were shown, as I mentioned to our Whip Gooch, the Secretary of State has issued many statements about all those things that were raised in the video. And the Secretary of State says our monitor was there. And in fact, since this morning, they've identified the person. It's a young white guy between 25 and 30 wearing a blue jacket that is in the video. That is their monitor that was there the whole time. Some people have filed affidavits not understanding that there is a duplication process when ballots can't be scanned, when they're torn, when they're UOCAVA ballots, because then when they're UOCAVA, Uniformed Overseas Citizen Absentee Voting Act, something like that, people are printing them on home computers at their houses abroad. They have to be duplicated, and there's a procedure for doing that. So you see a lot of these affidavits where people are like, this seems weird, this seems fraudulent, when actually it's the process. The human error raised in DeKalb, there have been, by Mr. Amick, I think, there have been numerous news stories about that. That would have been caught later in the process. If you canvass the vote properly at the county level before you go ahead and submit, you will catch things like that. And that discrepancy would have been identified even without, and I'm not saying he didn't identify discrepancy. He did. It's just that it never rose to the level of being a problem, and there's no evidence that it wouldn't have been caught. So it's not evidence of fraud. You know, people who think, oh, I didn't request an absentee ballot. Well, you're on the rollover list. 600,000 people. You know, so there's just a lot of things where we really need actual evidence of things that are provable, that are widespread irregularities that would rise to the level of having flipped the election. And, you know, we heard a lot about
a Dominion machine,
particularly out of Mayor Giuliani, about the fact that there were far fewer ballots rejected in this election. Well, that is true because we changed the law. We changed the law after the 2018 election to allow an opportunity to cure. And the laws related to the oath were also changed by this body. So these are all things that have happened. There are some innocent explanations for many of these things. And, you know, this was a very close election, but in the end, the number of ballots and the number of voters matched. After the hand count, they matched. The number of voters and the number of ballots matched, and that has been confirmed numerous times. We did a hand count with the human readable text for the presidential election. We're about to complete our third count. I feel like if we were truly interested in getting to the bottom of a lot of concerns that people have raised, and I do think that those need to be addressed because faith in our elections is crucial. People do feel that results can't be trusted. That is a problem. You know, first of all, there is the 23 investigators and 250 complaints at the Secretary of State's office. But even aside from that, if we were interested in finding out the truth behind statements being made, we would have a hearing where many of those could be discussed and we could ask questions of people that have knowledge about how Georgia's election systems are run. And we did not have that. So it seems pretty clear to me that we aren't actually really interested in trying to get to the bottom of some of these complaints. Could our election be run better? Human error does not equal fraud. Bad management does not equal fraud.
It can.
Of course we need to have secure elections.
It can.
I'm sure there are myriad ways that you guys think it could be run better and that I think it could be run better.
I think you could be run better.
But we do not have evidence of widespread irregularities that would change the election, and that's what you need to really talk about this. I've mentioned it 3 times already today. 40 judges and 40 lawsuits have not found that. Attorney General Barr has not found that. Brad Raffensperger and everyone involved in elections in Georgia have not found that. And with that, we get to this notion that we should seize the power away from the voters. I think we all know, and Senator Heath, Chairman Heath raised it, in order for us to even contemplate doing that, we would have to call a special session and change the law. The governor, speaker, and lieutenant governor have already said, we're not calling a special session. You need 3/5 of the legislature to call a special session. Clearly that's not gonna happen. If these folks have evidence of fraud that would change the election, they can and should present it in the courts and to the Secretary of State's office. People who have the ability to investigate,
they
recommend changes to us. And if there's a big problem, then let's hear it, you know? Then we have to take action. But until we have that, engaging in a lot of these things does more to undermine Georgians' trust in the election than it does to help it. Ever since today started, I have been attacked. The Secretary of State's office has had to take action as it relates to my address. And I've started to get some of the vile things that some of our other colleagues at the Secretary of State's office has. We've given it oxygen. And I think that does a disservice to so many Georgians. You got evidence, show up in court and prove it. That's how it has to be. And in the meantime, we've got OCGA 21-501F, where we have said that the person who gets the most votes is who gets the electors. And do we really want to mess around and have to redo every single one of our own elections too? I'm a little confused about that. Are none of us legitimately elected? Can anyone answer that for me? Do we know? I guess not, if we're not certifying the election. I really appreciate all of you for listening to, from where I sit, I see it. I know we've all gotten blown up since the election. I know that all of you have a lot more than me. Even I have. I know it's hard. I know there's so much pressure. And I know that with the tweets coming out of the White House, it's pretty darn difficult. And when you've got U.S. senators saying, resign, Secretary of State, it's pretty darn difficult to get up and be like, actually, the election was okay. I'm going to tell you the truth. That's pretty hard. I get it. We all are under a lot of political pressure. So I understand where you sit. Thank you for allowing me to make a closing statement, Mr. Chairman.
Senator Brass.
Brass monkey. Brass monkey.
Mr. Chairman, first off, I want to say thank you to you for being willing to hold this hearing, and members of the committee for staying here as long as you did. Regardless if we heard evidence of fraud or not, we owe it to our citizens to find the truth. And what we know is if we dig in and when we do find the truth, there's going to be a large part of this population in this state that is not going to be happy. But the truth is we owe them that. We owe each and every voter in this state an opportunity to see the truth. And again, we keep talking about the fraud, but for me, I want to know was state law followed? And we have heard clear evidence today that state law was not followed time after time after time. And that is a problem. And if state law was not followed in an election, then we do need to keep an open mind on a path forward. Again, you know, we all are under tremendous pressure, all of us, because this is a pivotal point in this state, in this country, and there's no decision that's going to be an easy one. So I pray for each and every one of y'all. I pray for myself that we all make the right decision, but I really pray that we dig in and we find the truth.
Senator Gooch, did you want to make?
Senator, I want to thank you for letting me be in here today. I'm not a member of your subcommittee, but I have been here all day. I started out with Chairman Heath in the first meeting where we had a couple of hours of testimony, and this meeting has gone on now for, 6 hours? I know now why I don't want to be on the Judiciary Committee. But let me get serious for a minute. As I spoke earlier this morning, I talked about the people I represent back home, just like each of us do. We all have a constituency, 56 state senators, roughly 200,000 constituents, and we work on behalf of them. We represent them. We are their voice while we're at work in this Capitol. I sit around the table at various meetings and at restaurants, and I talk to people on a daily basis, bus drivers, farmers, chicken farmers, cattle farmers, construction workers, nurses, school teachers, administrators, business people. And what I can tell you, what I'm hearing, and I'm sure you are, is that the voters and the citizens of Georgia have lost confidence in this election. Some of it may be because their candidate did not win. I get that. But I can also tell you, based on what I heard here today, going on 8 hours of testimony, we have a problem in this state. And we have a problem with our regulations, our ordinances, our laws, our policies. And we need to, as Chairman Brass said, we need to find the truth. We are obligated to seek the truth. I'm not sure how this committee or any legislative committee will find the truth without help from an investigative arm of government. So if you're trying to move toward a special session, let's approach it that way. But I think we need to move faster. We need to move deliberately, and I would recommend you consider requesting help from the Department of Justice, the Federal Bureau of Investigation, and the Georgia Bureau of Investigation to begin a full forensic audit of the November 3rd election in Georgia. And I think we should consider doing that this week.
Epic. Senator Kennedy.
Thank you, Mr. Chairman. What number is it?
I'm sorry, wait a minute. 2.
Yeah, thank you, Mr. Chairman, and I appreciate you and everyone staying for the late hour. I appreciate, as the mayor said, complimenting the minority for their approach to this. I would disagree with one of my colleagues in one regard. The comment that we don't need these hearings. I really could not disagree with that more strongly. We need these hearings. Our voters, our citizens need to see us having these hearings because they need to know that we, as their representatives, are willing to investigate wrongdoing.
We need you to actually
Senator,
give
you're
a
absolutely
shit
right.
instead of
We do need to get down to the truth. But I want to take it one step further. We need to have accountability for those that have engaged in wrongdoing. That's the next step. That is the step beyond fact-finding and truth-gathering. We've got to have accountability. You can't have accountability if you don't have these hearings. If fraud and impropriety are occurring, you can't stop it by just lamenting after each election, wow, that was a mess. I hope it doesn't happen again. It won't change. It won't change. So what we've got to do is figure out some form of accountability, and we cannot expect anything to change with regard to what seems to be the perennial fraud and impropriety in certain precincts and certain areas that occurs every election unless we start and decide to have some form and measure of accountability for those that engage in fraud, those that engage in wrongdoings, and choose to violate our law. Mr. Chairman, thank you for your patience. Thank you for staying late. I appreciate your leadership on this committee. Thank you. And I thank all my colleagues for being here.
Senator Summers, you want to say something?
Mr. Chairman, thank you for allowing a non-member to sit at the table and be engaged in these topics. Guys, I've run 4 elections in 1 year. I will happily run another election if we can get a fair and balanced election in Georgia. She asked the question, I'd gladly do it again. I'm telling you straight
New
up,
poll
I
on
totally
Facebook.
believe that we should be called into special session and allow the legislative process to take place and make sure, as several of these senators have said, that we give people the honest truth about the election. Whoever wins, wins, but we need to know the facts and we need to know who that person is. And I would gladly do a re-over in my election if that's what it takes. But boys and girls, we're here to vote and stand up and be strong. It's time we acted like legislatures and come together, ask our governor to call us in for a special session. He wins either way. If we find no improprieties, the governor looks good. If we find improprieties, the governor looks good. Let's get on with it. Thank you, Mr. Chairman.
Senator Beach.
Yeah, Mr. Chairman, I want to thank you for allowing me to be on this subcommittee. I'm not on judiciary, but thank you for allowing me. And I also want to thank you for all the hard work you put into this. For a guy that's leaving office, you have put in a lot of hours on this, and I just really want to thank you. But I just would say I'd agree with my colleagues. I think Senator Brass hit the nail on the head. We got to get to the truth. And then I think you hit the nail on the head, Senator Gooch. We got to restore voter confidence. I can tell you the voters have lost confidence in our system. And I'm going to tell you, in my 8 years here in the Senate, I have never received so many emails, phone calls, text messages. I put my cell phone number on my website and on my Senate page, so I've been getting a lot of calls. And I want to just share one of the calls that I keep getting. And I had a lady call me, and this is kind of the calls I'm getting. And she said, Senator, she said, I stood in the Alpharetta Library for 2.5 hours to early vote. And I went in there, I showed them my driver's license, my photo ID, I signed my name and matched the signature in the database. I got my card, I voted, I checked my ballot, I scanned it. She said gave the stylus pen back, I got my sticker, I walked back to my car, and I was proud I waited 2.5 hours to vote. I didn't have a problem with it, I voted. Now she said, because of the agreement that Senator Dolezal talked about with the Secretary of State entered into, she said, I know now on absentee ballots, they don't have to show ID. The voter signatures don't have to match with the database. And she said, I feel like my vote was compromised. I feel like my vote was diluted, and I feel like my vote didn't matter, and I'm not going back to vote in January. I said, ma'am, I need you to go back and vote. You got to go back January 5th. But that's what we're dealing with right now, and that's why I'm so glad we had these hearings. I wanted to tell that story so that we could get to that. And Senator Kennedy, you're right. We can't just wait and think that things are going to get better at the next election. We need to take action. That's what the state of Florida did. If you remember, we heard today, in 2000, they had a mess on their hands with the Bush-Gore election. They got the results back in by 9 p.m. on election night, and we were still counting votes 2 weeks later. That's ridiculous. It's uncalled for. And Broward County and Dade County were a mess. They got it cleaned up. They've got twice the population we have, twice the elderly population, had more absentee ballots, and they're on 2 different time zones, and they got their votes in and called at 9 o'clock. Our goal as a state, in my opinion, should have the election results by the 11 o'clock news, the night of the election, so our voters know that we've got the winners and the losers, and we should be able to do it. But we got to get to the truth and then figure out how to make it right. So I just, again, I'm glad we had this. I hope we dig into it and have investigations and make sure this was a fair election and make sure the elections from here on out are fair. So thank you for all your hard work, Mr. Chairman.
Thank you. Senator Tillery, did you want to say something?
Thank you, Mr. Chairman. I think I asked a lot of my questions earlier today, but thank you for giving me a second to close.
It's the door again.
First, I want to thank the members of the committee. I appreciate your cordiality today and how you handled things, even though I know there was a lot of passion.
It's the door again.
But I do appreciate how you handled yourselves. There were things I learned today. When I came into this room, I'd gotten a lot of questions, just like many of you, from calls from your constituents. And because of some of the things I heard today, I think I'm better prepared to answer some of them. I'll carry you back through just 1 or 2 of them. When we heard from the colonel, and he mentioned about things from Dominion, I'm sure you've gotten a lot of calls about that as well. And we walked him through, and he got to the end, and he said, if you did a 100% recount or 100% canvass, then I would have to say it would probably remove some of my concerns about a glitch.
It's a purdy door.
That was testimony you heard here today. When you heard from Grace Lynn, the student from Georgia, who talked about not being able to, going in and hearing that she had already requested an absentee ballot. I know I've heard that 100 times. I'm sure you've heard it as well. The testimony that we were able to get from her, and then thanks to Senator Jordan, Senator Dolezal, and others, we were able to show her, no, here's how that actually works, and we were able to help answer her question, which watching that is going to help me answer questions for my constituents. Those are the things I learned. That's where I was able to grow, and I can answer questions from my constituents. But there was one other thing we saw today, too. One of our senators already mentioned an Alice in Wonderland moment. That happened for me, too, today. And that happened when I believe her name was Miss Pick, played her video. I can't explain that one. I cannot go back with that video and help my constituents understand what was done and why it was done. When I see the table come in at 8:23, it's got a drape all the way over it. I see something happen at 11:23 later on. I see folks leaving at 10:30. I can't answer that one. That's the one that I'm going to be focused on trying to answer as we move forward. Mr. Chairman, I want to thank you for your help today answering questions that our constituents bring, members of this committee. But I remind you that our work doesn't end today. Thank you, Mr. Chairman.
Okay. You want Senator Jones? You want to? Yes, sir. Let me make sure I have you.
14 here.
Yep, gotcha.
Senator Ligon, Mr. Chairman, I just want to thank you. I echo what Senator Beach said about, for the amount of work, knowing that you've served distinguishedly 10 years in the Georgia legislature in the Senate and know you're heading out well, you and Senator Heath as well, but for the work you've put in for this committee, I just want to, from the bottom of my heart, thank you, because you show that you're a true public servant and a true patriot for what you've done. The one thing, I'm glad we got to have this meeting today, because there's one thing that all of us have in common in this room. We've had 3 election cycles now, 16, 18, and 20, where all of us have been disappointed in the results. And each one of those election cycles have brought forth allegations of some sort of mischief or fraud or things of that nature. And it's our job as elected officials, especially when those allegations are in your own state, it's our job as elected officials to seek out, as Senator Brass said, the truth and what has transpired. And what we saw today, I was like Senator Tillery here. I was seeking answers to questions to share with constituents, and like as he eloquently said, what we've witnessed today with the video from the State Farm Arena, those have raised a lot more questions about the process, as well as what went on, particularly in one county here in our state. So my only regret is that we haven't started these hearings sooner. However, with the findings of the video just coming out as of last night, maybe it is in our good fortune that we started the hearings now. But I definitely think that moving forward, and we need to move quickly in trying to establish what a significant forensic investigation would look like, and what role do we need to play in legislatures as legislators of seeking not just to answer questions from November 3rd, but prevent it from happening on January 5th, which is the most important election we have right in front of us here. So thank you again, Senator. I also want to thank Senator Dolezal for your behind-the-scenes hard work, as well as Senator Beach. I know y'all put in a lot of work and a lot of hours making this happen as well. So, but thank you, Mr. Chairman. Appreciate the opportunity.
Thank you. Anyone else before I close? Senator Dolezal and then Senator Heath. Go ahead, Senator Dolezal. Let me get you.
Mr. Chairman, you've been exalted, and I'll echo the exaltation. And I will extend that to Chairman Heath as well. I thought that the meeting this morning laid a nice groundwork, and it was nice to be able to Senator Tillery's, Mr. Chairman Tillery's point earlier, to be able to ask questions of the Secretary's staff, if nothing else than to inform ourselves and inform our constituents, is to the way that this works. What didn't get discussed today that I think is important to illuminate is the fact that we discovered, really by accident, significant structural flaws in the way that we conduct our elections. We had 4 counties discover thousands of ballots via a risk-limiting audit that was never supposed to happen. The audit wasn't supposed to happen this year. It was supposed to be a pilot that was happening in the future, and it was never envisioned to be every county counting every vote, period. So the system worked because we got lucky. We have a significant problem when we don't know when we finish an election that the numerator matches the denominator. The fact that we don't know the denominator. We hear at one point in time at 6 o'clock one morning that there's 25,000 more votes to go, and then we hear at 10 o'clock that there's 45,000 more votes to go. I understand somebody may have misspoken that, but there's no master place that any one of us could go to the Friday after the election and say, here's how many votes are left to count, because we know how many ballots came in and we know how many ballots have been counted. That's simple blocking and tackling when it comes to functioning something like this. This is one big data exercise. And we have to get the blocking and tackling correct to instill confidence
This is the guy that
in
asked
this
earlier
process.
what
Because when
encryption
you find
standard.
thousands of missing ballots, when you hear that one number is still outstanding, then you hear that another number is still outstanding, there's none of us that can stand behind a podium and say this process is working well. We keep hearing this caveat around the irregularities or the fraud. And the caveat is that it's not enough to change the outcome of the election. That's the consistent caveat. Gabe Sterling said in a press conference that he knows there was fraud in this election. How does he know that? Is he wrong? Is he right? What he also said was, but we know it's not enough to change the election. How does he know that? There's 250 open investigations and probably should have been more. We heard this morning from the Secretary's office that 300 people double voted again. We had 1,000 people double vote in June, apparently. 300 double voted this time. They said the number was down. They told us there were 70 felons that voted. We've heard about thousands of people where their ballots were sent out of state. We were also told that we know that we're asking a lot of the election officials to review 1.3 million signatures, something we've never asked them to do before. The Secretary tells us it's not the best way to do it. But we won't even go through the process to review a random sample of those signatures to figure out how well we did. That's unacceptable. We owe it to ourselves as the people that are charged with the responsibility of getting this process right to understand when the system was stressed and when it was flexed, how did we perform? There's not one business in America that would go through this process and have something change in that manner and do zero review. And ladies and gentlemen, when it comes to the signature match process, we've done zero review. It may have been flawless. I would like to be able to say that it was flawless. But I don't think that any of us believe that it was flawless. Because I don't believe that any of us think that our signatures are consistent enough over a period of time from when you last got your driver's license. Senator Beach, I'm sure you got yours within the last couple of years, but I got mine 10 years ago. My signature's changed.
So is your hairline.
There is an incredible amount of disinterest in the media and frankly from the minority party in really digging into this process. And I do respect the senators who were here today, but there is not a call for a signature audit. There has not been a call for investigations. We've heard for the last month that this State Farm Arena situation was under investigation. Why did it take us a month to get a video? Why did it take us a month to get a video and it wasn't even produced by an employee of the state? That's patently absurd. We have to do better, and we can do better. That video is a bombshell. You saw the media and the observers leave the room at the same time. That tells you they were told to leave. Why were they told to leave? The media needs to get interested in this, and they need to get interested in this quickly, because they have a role to play in this as well. And the fact that I can guarantee you, well, I can't guarantee you. I would suspect that if the allegations were on the other foot and in the other direction, that we wouldn't have waited a month for an open records request to be filed, or however they obtained that video to see that video. We have to get a lot more curious because we have to get it right. And Senator Parent, I'm not intending to throw you under the bus, and I apologize for my comments about what I just said, but I do really wish that I sensed a bipartisan effort to dig into the details of what happened so that we can affirm it in either direction. This, to me, is not about who won an election. I don't think this is about who won an election to you. I don't think this is about who won. You referenced, maybe our elections aren't legitimate. We don't know what happened because we haven't lifted up the hood to look. 1.3 million signatures, and we haven't bothered to look. And I would like to link arms with anybody, regardless of party, to get to the bottom of exactly what happened so that we can move forward, and quite frankly, so that we can do a better job and know what laws we need to change. we've all gotten a little bit of a baptism by fire in election law and what our state laws say, but whether it is a special session, which I do think we need to have, or it is when we come back in January, we have our work cut out for us, and we don't know what we need to change unless we look at exactly what happened. Thank you, Mr. Chairman.
Senator Heath.
Thank you, Mr. Chairman, and senators, people who have persevered throughout the day. I don't have much to add to this other than just a few observations. Someone had mentioned earlier that, mistakes are not necessarily criminal, or I don't remember how the comment was made, but I agree with that. I think we all make mistakes. We've all misinterpreted things. None of us are perfect. But what's potentially at risk here is at least the direction that this country takes. I think that, well, number one, it is exceedingly embarrassing that we're having this discussion. I remember watching the videos of, the 2000 election when Florida going through a similar process, and I was kind of laughing like, those guys have got to be a bunch of idiots down there. And maybe I should not have had those thoughts, because now the camera's on us, and it doesn't look good. But there's enough mistakes that have seemingly been made. I don't think anybody will come out of this clean, including the legislature. When you go back and look at what the legislature has done, and I think I've been around to see a whole lot of these laws that we're struggling with right now. I saw a lot of those taking place, and I kind of remember the mindset as we did various things, and I look back on it and I'm thinking, yep, we thought we were doing the right thing, but now I don't think that it was the right thing. And guess what? That's what we do every time we get together. We're tweaking what the previous legislature has done. There's not a lot of brand new, clean ideas that come out of the legislature. As I sat and listened to the witnesses in the Government Oversight Committee meeting this morning, admittedly, I could sit there and pick through some of that and say, well, maybe that's not a false statement, but it might not be the whole truth either. As I sat here and listened today, this evening, this afternoon, same thing. Certainly, everybody that testified gave you some reason to suspect that things were not done properly. Maybe they weren't intentional mistakes, maybe they weren't intentional acts, but there were certainly opportunities. And then the professor that, essentially his position seemed to be that, okay, boys and girls, this is in your hands. You should exercise your power as a legislature and straighten this out. If the legislature can convince itself that we have created an environment where you can't conduct a true and accurate election, then maybe we do need to step up. But before we get to that point, we would be setting a precedent there that is, you just need to be very careful. The legislature has a problem that I know we have discussed for years, and that is that we can't swear witnesses in a committee. So you can come here and stand at that podium and say anything you want to say, and there's no recourse. So the problem that we've got as a legislature is that now we've got to take that information with the very limited staffing and capabilities that we have. As a legislature, we're essentially one-man shows. There's a few of us there's a few legislators who have one admin assigned to them, very few. There is no legal staff that is assigned to a certain committee chairman or a certain legislator. We all use the same pool of resources, and it's very shallow. So those are some problems that need to be resolved, and the problem that's in front of us right now
whining
is that
we don't know what the fuck we're doing.
For us to take any further action, I think the first thing we got to do is go on our own to find the facts. Now, we talked I think it was the colonel was talking about the Dominion machines and voting machines as a whole. I will tell you that there is a risk at exposing how that machine works. I read, somebody told me that somewhere on a blog, that the source code for these machines is open source and it's available to everybody. Well, I don't know if that's true or not.
It's not. You should probably
But I can tell
know.
you that it is very difficult, if you know exactly how a machine works, not to figure out how to break it. So there's some risk in opening up that to the public, to any investigator or hacker, if you will.
Somebody wrote me a 12-year-old that knows how to use a computer.
But
Grandpa
there's
needs
also
help.
a gain there in that now, at least the allegations, the appearance is we don't know what can happen. I think I could write software that would not be corruptible through a USB port.
I don't think you can write
But
a
I don't know
sentence.
that that's the way that software is written. I have heard them, testimony about, Fulton County said they had this mobile voting precinct. Well, that to me implies that you got to reload data. When you move it from one precinct to another, you got to reload data. But there was also testimony that says nothing just changed in them in the final hours. So there's a lot of work that we got to do before we take any drastic
Once they've
actions.
been certified, they
But I
can be
think that we
updated.
got to get started on it, and I don't know who's best to work on that, but there is a world of work to be done, and I really don't know that if we had all 56 senators working on this, dedicated, 8 hours a day, 12 hours a day, 7 days a week, that we can really resolve all this. But we got to do what we can do. We got a mess on our hands.
Oh my God.
And as has been stated, this whole a democracy is dependent upon being able to trust the outcome of elections. We've got to do something to restore not only Georgians' trust in our elections, but the country has got to trust our elections. Georgia is significant to the United States of America.
over facts.
So I don't have any answers.
Corn
I do
pop
see
was
there's
a
a lot of
bad
problems. And just as I stated in my committee this morning, it was exceedingly difficult to put that committee meeting together. I know this one was as well. I don't know about the legalities, but if you want to go to a county and say, I want to see this shut up house, and I want to study them, I want to feel of them, I want to resolve some of these things. So there's a security risk at that.
Oh my God, dude! You have not
Because,
said anything
frankly,
of
I don't
substance in like
trust
fucking 5 minutes.
every
Shut
legislator.
up.
So, there's a balance here that we got to strike, and
Yes, and it's called fucking
I
silence
don't know how we get there
versus your
but
voice.
We got a mess on our hands.
Stop.
Thank you, Senator Heath. Senator Harper? You number 10?
Yes, sir. And I also want to say thank you, although I'm not a member of your subcommittee. Thank you for letting me sit in this afternoon. I appreciate it. But being a member of Senator Heath's
He's
committee,
all by himself.
I just want to express, as others have, to both you, Senator Ligon, and Senator Heath, both of our chairmen today, for your outstanding, I think, run hearings both this morning and this afternoon. I think y'all both did a phenomenal job. You should be commended on the work that you put in prior to today, and the work obviously that's going to continue going forward. So thank you both for doing that. And I think it's all evident why we are all here. I know Senator Gooch referenced this, and many others have. You know, like Senator Beach, in my 8 years of service in the legislature, I can't think of another single issue that I have heard from more of my constituents about than this one issue that we're here discussing today. And I agree with a lot of the comments made. One of the roles of the General Assembly and one of the roles of the legislature is oversight. And that's why we're here today, and that's the whole purpose of us convening these hearings today is to provide that oversight that we're expected to do on behalf of the constituencies that send us up here to the Gold Dome to represent their behalfs. And I think that's why we're here today, and we should do these things. We should have these type of hearings. We should investigate issues when they arise. And I want to say thank you to the Secretary of State's office this morning, Fulton County, and all the witnesses that showed up, Mayor Giuliani for coming today and providing testimony. I think it was awesome opportunity for us to have an open forum and discussion to be able to ask those questions of all of those entities. To Senator Parent, I'm going to reiterate what I said this morning to the Secretary's staff and their folks. You know, if you have received threats today because of things that you may or may not have said, I hope my colleagues will join me in condemning any of those acts or outlandish threats that may be coming toward you, and I reiterate my comments this morning in condemning the same things against the Secretary and his wife and his staff. I think that's unbecoming of us as citizens, and that's not who we are as a basis of an American citizenry and the democracy that we all enjoy. And I think those type of things can have an impact on the foundation of government that we have. But the questions that we asked and the answers that we were able to get today, I think it boils down to a couple of things that it's already been said. It's about getting to the truth, and I think Senator Brass summed it up well in his statement of was state law followed. I think that is a legitimate question, and I think the longer this hearing went today, I think there's more questions that can be asked. And I think if you look at the hearing that was conducted this morning and the hearing that was conducted this afternoon, I think there's some differences in those presentations that should be looked at. In whether we're talking about chain of custody or signature verification or signature match issues, as Senator Dolezal has very adequately presented on today. And I think, you know, all of this laid out is giving us an opportunity to lay a foundation for us to take some action, as Senator Heath has alluded to. That I think this has given us an opportunity to lay the groundwork and lay a foundation for us to look at our laws and make sure that our election law is proper. And if we need to make those adjustments, we can make the proper adjustments that need to be made, and we can give voters the confidence that they need that our election system and our state is secure.
The longer
they
you
know
talk,
that
the
when
less
they cast their
confidence I
ballot,
have.
they know that their ballot is counted, and that they can have trust in our system of self-government, because without that foundation, we can no longer be a nation that is governed by the people, or a nation that is built on the foundations that we were built on as a country and as a state. And I just want to say thank y'all. Thank you both again. Thank you to all the committee members. I thought this was a well-run committee. I thank you to everybody for the cordial conversations that were had. I think this just has given us an opportunity to have a transparent process for our constituencies to see, and I think that's all they've been asking for. So thank you both for allowing that to happen.
No.
Well, let me close out
We've been
by
asking for more than just for you
thanking,
to sit
first
there
of
and
all,
listen
all of
to
the
us.
citizens of this state who have reported what they see as irregularities or misconduct or fraud. and that have contacted your legislators to ask them to look into that. That is part of your civic duty.
Amen to that.
And part of our duty as legislators is to look into this and to have an appropriate solution that will resolve this issue. I want to thank Senator Stone's staff, Layton, for helping put this together. She's worked very hard and has stayed late, and others. I want to thank some senators, Senator Dolezal, Beach, and Jones, for helping. They worked hard to help put this together as well. I appreciate all of your efforts. And others, Senator Heath, for your work earlier. You've been here all day. Some of you have been here all day on the 2 committees. Thank each one of you for being here. I do think this is very important. It's something that we needed to do, and I know that there's a lot more work that will be done in the future, in the near term, and also in the long term. So with that, we're adjourned, and thank you.
Sweet baby Jesus. Oh, okay. Well.
We can't thank you enough for supporting us at Right Side Broadcasting Network.
Yes, thank you, Right Side. We appreciate you. You're awesome. All right. So, I appreciate everybody sticking with us, watching it. I don't know what you guys got out of it compared to what I got out of it. I hope, as with all of these hearings that I've watched, that more than just sitting there, that they actually realize that we want them to do something. Sitting there and listening to us is great, but it's paying lip service. I don't want you to just sit there and listen. I don't want you to debate for the next 3 years what's going to screw us 4 years from now. I want you to do something. Period. So, stay on whatever state you're in. Stay on your local politicians to get their shit together. Like, if you were around in the 2000 election, you'll remember everybody got to get rid of the electoral college. Got to get rid of the electoral college. Go to the popular vote for like 2 years. Every article, every news story after Bush won was, we got to get rid of the electoral college. It's not fair. 20 years later, we're still using the electoral college. Now, I'm not saying there's anything better than the electoral college. What I'm saying is, we don't keep on these people. They're never going to actually do anything. And the problem has become, we have moved, even if you take this election out of it, we have reached a point in human history where we have gone from a system of voting that can be easily understood by anybody that volunteers. Everybody can understand how to mark a piece of paper, read a piece of paper, sort a piece of paper, and count a piece of paper. But as soon as you start putting electronics in it, the number of people that know what's supposed to happen, that can look at the computer, not at the process. It's easy to train somebody on, they hit this button, it prints out this, it prints out a QR code, and it goes in a scanner, right? But how many of those people that aren't Dominion employees, or insert whatever machine company in there, how many of those people actually know what that computer is supposed to be doing? Or any way of being able to look at that piece of equipment and know that it's operating in the manner it's supposed to operate. As we've moved to more and more digital ways of doing things, the number of people that have the scope of knowledge to know what they're looking for to see when this is happening gone down. I have 28 years of IT experience, programming, hacking, all of it. I live in Georgia. I voted in Georgia on a Dominion machine. I can't tell you that machine did what it was supposed to do or not. That's a problem. Because I guarantee you, knowing the people in my county, I have more IT experience in the needed realm than anybody that was in my precinct. And that's a problem regardless of what side of the political spectrum you're on. And one that we have got to fix quickly. I appreciate everybody. All of the videos from the Arizona yeah, all of the videos from Arizona are up, and
We are
they are all up there individually, so you'll be able to do the same here. I've got all the Michigan testimonies are about to go up in individual videos also, so you'll be able to watch them individually instead of having to skip through a large video. You'll also be able to share it, which is one of the reasons I did that. But they are currently, you can get to them from either protester privilege or from Kraken. Pull it up real quick. So here's Kraken. Go playlist.
With that,
This
Senator
is-
Colbeck, welcome to the Senate Oversight Committee. I know you had a long flight to get in, so thank you for getting here.
Now, so this is every witness individually with all of their information for that entire day. And what I'll be doing is doing that for each one of the hearings with testimony, and then I've got a couple other Roger, I did not see network cables. However, that doesn't really mean much. The fact of the matter is the concept of air gap, and you've probably heard that from the colonel and a couple other people. The concept of air gap predates wireless IP technologies. Back when you literally had to use a cord, you don't have to do that. I can buy, I can go to Amazon right now and buy an ESP8266, which is about the size of a MacBook, in his computer with built-in Wi-Fi, and I can plug it into something and completely take over. What I don't think people will fully understand is in 2000, part of what the problem was after 2000 is Diebold voting machine had just come into their own. There were voting discrepancies in Florida during the 2000 debate that could not be reconciled, that could not be cured, because the hard drives that were holding the votes corrupted. And if you go look up the news articles from that point, the hard drives went missing. Then they randomly came up a couple months after, in March the next year, in the possession of the FBI. Now, there were other counties that weren't using voting machines at that point, that hadn't gone to digital, which is why we had the hanging Chad problem and why we actually had something to fight about to figure out who won. But there were votes in Florida that should have been counted that didn't get counted and could have changed the rates. But, like I said, it's really, as a society, as a country, as a citizen, we have to understand that the push to digitize things, the push to make things more efficient, blah, 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 you lose things with that. And in this case, we lose control. So it's kind of like you see all these guys sitting on these committees. The people that sit on the I think it's the Science Foundation or National Science Committee or whatever, that the House committee that oversees NASA's budget. There's only one scientist on that entire committee. So I think the video that came out today is quite interesting. If someone can go and explain everything that is going on, which I find it very hard to believe that they can, then so be it. But I think we can all pretty much agree at this point that cheating on a higher than normal level or vote fraud on a higher than normal level was occurring. If you look back, I think just as much was occurring in 2016. I just don't think there were any elections that anybody gave enough of a crap about to stir the pot. I think that's what everybody's like, well, what do you, don't you think they would have figured they got caught? No. Because they never did in the past. Our society moves too fast. We have a very short attention span. People use that against us. I can do something stupid. I can grab something out of your hand if you don't remember 3 minutes later. That being said, I'm going to get back to making videos. I'll be posting, I made some highlight reel of everybody's favorite Cynthia Johnson last night, the Michigan rep that acted like a complete fool the entire night. So yeah, I got some highlight reels that I'll put on the Facebook pages, and then I'll have the full playlist on YouTube so you can share. Don't know what is going on tomorrow that'll be live streamable. I know Saturday is President Trump is having a victory rally in Savannah, Georgia, Saturday. So we'll be covering that. And then we should be hearing back about the Nevada or Arizona lawsuit. But I'll keep it everybody. Like, subscribe, share, and hit the little notification stuff. You'll get a notification next time we go live. Appreciate everybody. Anything, just message me on one of the Facebook pages. Appreciate it.